public that have
Okay.
joined?
Okay, if I can interrupt for a moment, apologies.
Yes.
I see that the presenters are not yet accepted in the meeting. They are waiting in the lobby.
All right.
I suggest maybe we get that first before you address them, Chair. Thanks.
Thank you, Mr. Matebula. So we'll hear from IT once the presenters are accepted into the meeting. Thank you for that.
Chair, this is Patience. I'll be assisting as the secretary for the public hearing. Chair, if you can please just give us a minute. We are busy accepting stakeholders and members of the public.
All right, thank you for that.
Chair, through you, is there a problem with IT? Because we have never experienced this from the Secretariat for people not to be able to join. There's a lot of people that are on the line, and now we are delaying the starting time. Maybe IT must assist if now the Secretariat is not able to do it.
IT? I see.
Good afternoon, Chair. Good afternoon to the members. Chair, there's no problem with IT. Secretariat is the person that organized the meeting. So by delegation and by segregation of duties, it's the only person that can admit members at this stage.
I was just asking Chairperson that IT must assist. We are just one team here at NERSA, so that the issue of the duties and all of that, if now she's struggling, she needs IT to just step in and assist.
Can I ask IT to step in and assist? Let's check where she's struggling with, because we can't keep the public waiting.
Will do, Chair.
Is it possible at this stage to reassign rights so that we can, most of us can be able to also enable people to join the meeting? Please, if you can do that, I think it will speed it up.
Chair, we apologize for the inconvenience. We are busy assigning rights so that we can assist each other in accepting the people.
Okay, but let's try and speed it up, please.
I don't think, Chairperson, assigning rights is going to solve the problem, because all people that are not NERSA are the ones that are unable to get admitted into the meeting. It's only NERSA that is admitted in the meeting. So assigning the rights, I don't know if it's going to help. The problem is in the way that the link was created by the person who organized this event.
Can I just check with IT whether there is an alternative way of speeding up how we accept the members of the public?
Good afternoon, Chair. No, Chair, unfortunately, there's no alternate way. There's 97 people waiting in the lobby. And at the moment, Ms. Patience is the only one with the rights. So she's assigning rights to the rest of us so that we can just try and expedite the process.
Chair, if I can provide clarity, Mr. Mabunda is helping us to assign the rights to myself so that I can take over.
But I thought we're going to assign the rights to more than one person so that we can speed up.
Yes, correct, Chair.
Alternative, Mr. Mabuda may just join for a short while, if possible, accept people in and then bow out.
Madam Maswanganya, is it possible to ask Mr. Mabunda to accept the people and then bow out as suggested by Mr. Mkize? And I see the number is increasing now. It was 97, it's now 101.
Afternoon, Chair. Is it possible if we can stop the live streaming while we're doing this admission, Chair? Is it fine if we request Ms. Maputa to stop the live streaming while we do this admission?
Look, and all right, we can stop it, but how are we going to know now that it is sorted out? Hello?
Secretariat will indicate, Chair.
All right, I think let's stop it then. Are you going to indicate what? All right. But how are you going to indicate? Are you going to send us an email?
Chair, people have been accepted in. As they come, then they will be accepted in. But most of them are accepted into the public hearing. Thank you.
No, I see. It says now 5 waiting.
Yes, as they come in, then we accept.
All right. So can we start then the meeting?
Yes, please. We apologize for the inconvenience.
Good afternoon, ladies and gentlemen. It's Willie Majola here. I'm the chairperson for this meeting. Firstly, I would like to apologize for the delayed start of the meeting. We had some technical glitches with regards to accepting the members of the public. So once again, I would like to welcome everybody to this Electricity Subcommittee public hearing on the market code and market rules. As I've said already, my name is Willie Majola. I am the full-time regulator member responsible for electricity regulation. I will be the chairperson of this hearing. I would now like to introduce the members of the panel. As I introduce the members, I kindly request they greet the public on video where possible. So I would like then to start by asking Madam Maseti, who is a full-time regulator member responsible for piped gas regulation and also a member of the Electricity Subcommittee.
Good afternoon, Chairperson. Good afternoon to the members of the subcommittee and everyone who has joined this public hearing. Thank you.
Thank you, Madam Maseti. I would also like to introduce Mr. Mkize, a full-time regulator member responsible for petroleum pipelines regulation and also a member of the Electricity Subcommittee.
Warm greetings to you, Chairperson, and everyone on the call. Thank you.
I would also like then to call upon Madam Simani, the chairperson of the Finance Committee and also a member of the Electricity Subcommittee.
Afternoon, Chair. Afternoon to our NESA colleagues and members of the public. I'm Tembeka Seman, part-time regulator member here at NESA. Thank you.
Thank you, Madam Simani. So this hearing was duly advertised in various newspapers, on NESA's social media platforms, and on the NESA website. It is conducted in accordance with the Energy Regulator Act, which provides affected parties with an opportunity to submit their views and present relevant facts and evidence to the energy regulator. The hearing is governed by the NESA rules on public hearings, which may be summarized as follows. All parties are required to make their presentations under oath. Applicants have been allocated 15 minutes each to present. Only members of the panel may ask questions to presenters. However, members of the public may submit questions via email to publichearings@nersa.org.za, after which the panel will determine how such questions will be addressed. And should any presenter wish to present information deemed confidential, the panel will rule on whether the hearing should be closed for that portion or whether the information should be submitted in writing. Please note that the audio recording captured via the microphones will constitute the official record of the hearing. The following house rules apply for this meeting. All participants are requested to remain muted when not presenting, unless invited to speak. And please keep your video switched off unless requested by the chairperson to switch on. NESA has received 10 requests to present. We will begin with Mr. Bala from NTCSA. And then when we when we ask the presenters, then we're going to ask them to switch on their cameras. So we're starting therefore with NTCSA. I see here it's Mr. Bonde Pala and Mr. Andrew Ettinger. So Mr. Bala and Mr. Ettinger, please switch on your cameras. And Secretariat, help me when they've switched on their cameras, because switch on your camera so that you can take the affirmation.
Good afternoon, Chairperson. If I could please point out that Mr. Bala is unfortunately ill and will not be attending, and I will be standing in for Mr. Bala as well. Thank you.
Thank you, Mr. Ettinger, for switching on your camera. So please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the whole truth, is the truth, the whole truth, and nothing but the truth? Response?
I so declare, Chair.
For the record, please state your name, organization, and designation.
My name is Andrew Ettinger. My organization is the National Transmission Company South Africa, SOC Limited. And my position is General Manager for Energy Market Services and International Trading.
Thank you. Please remember to forward your presentation to public hearings at nesa.org.za. So you may start with your presentation of 15 minutes. Over to you.
Thank you very much, Chairperson. I will then share my presentation if that is in order. And if I can ask one of my colleagues to share it, please. I don't seem to have it. My apologies. While it's loading, Chair, if I could make some introductory comments on behalf of NTCSA, which is to thank NERSA sincerely and everybody on the call, as well as all contributors to the development of the first pass market code, which serves before us today. We understand that this is an evolving process, and that while I think many comments have been received and incorporated to the best of our ability, that there will always be areas for improvement. And I think that's is the experience in jurisdictions around the world. I think in countries that are 25 years ahead of us, they are still refining and reviewing their market code. We really do appreciate it, and we undertake from our side that we will certainly give full attention to all the comments and questions that come through during the course of today's hearing. I think the presentation is about to be shared by my colleague, Mr. Bowen, and then we can get going. Chair, thank you very much. But I think we can go to slide 2. Slide 2 of the presentation, Chair, talks about the process which we followed over the past 2 years or so in developing the code. And we started out in 2024 by launching by the participants on this call. And on average, we had about 450 people at the venue as well as online to take part in this. By the end of that series of workshops, I think we conducted 10, and there were an additional 2. So it brought up to about 12. So really an extensive exercise undertaken during that process. There was an invitation at the end of all of those workshops to provide written comments to us, and once again, a substantial amount of comments and excellent comments and contributions were made, which we methodically worked through. Obviously, in certain cases, we could accommodate the comments, in other cases not. But what we did do is, in many instances, particularly with associations and groupings, that we met with them to do a page turn through their particular comments and discuss, and in some cases debate elements of the market code. So really a robust process that was followed to bring us to this point. There was a second round of consultation launched towards the end of last year. And once again, I think what we found is that in many instances, stakeholders, as we all were in a learning process, had new comments, new questions, etc. So we decided to go on a second round. And that resulted ultimately in the finalization of the code version which serves before this hearing. That was approved by our board of directors and submitted to NERSA for their processing, and that brings us to today. If we go on to the components of the market code, there's essentially four aspects to us. The first is the institutional and governance structures which we envisage to run and be around the market, and this really defines the entities responsible for implementing and overseeing the market. And these roles would ensure that market administration is efficiently done and effectively done, that the system operates reliably, and that there is a required level of oversight. I think the oversight and the mechanisms for that is one of the aspects which receive considerable attention, and I'm sure will be picked up during this afternoon's deliberations. Secondly, in terms of the operations of the market, as one would expect, covers all the processes involved in running the market and the financial reconciliations after transactions have taken place, and would work together with this, obviously, with the system operator as well, just to make sure that those interfaces are correct. Market participants, important to clarify exactly who qualifies and what the registration process is and what the code of conducts would be for market participants. And then lastly, the rules, procedures and compliance framework, as one would imagine, is a set of rules that governs aspects such as transparency, fairness and market conduct. And these rules ensure consistent participation, enforce compliance, and support dispute resolution and monitoring. Once again, this is an aspect which where there were many different opinions as to how that would best be achieved. Thank you. Let's move on to the next slide. The market code in itself, as everyone on the call I'm sure would be aware, consists of 16 chapters. The first two are of a introductory nature. Chapter 3 deals then again with the responsibilities of the various parties, specifically the market operator, NERSA, the system operator, market participants, and network operators, obviously all of which have a key role to play in making this market work. 4 deals with the governance and the structures around those players that would be necessary to make sure that everything hangs together, and that ultimately we comply also with the law, which is described in the Electricity Regulation Amendment Act. Point 5, not everything goes according to plan. There could be disputes, and the dispute management process was arrived at and debated and workshopped, and serves in Chapter 5. The market participation and balanced responsible parties describes how admission will work, what default looks like, and how that would be remedied, suspension, termination, deregistration, and force majeure events that occur, and how they would all be handled within the market. Chapter 7 deals with trading resources and standing data, and talks about the data requirements, including registries, the common information for trading units, and additional information for constrained or storage units and interconnected data. Obviously, the transparency is a critical aspect of any market, but some information would nevertheless be confidential, and that would need to be borne in mind as well. International trade is an interesting one. This is an area where our markets differ slightly from a lot of other markets around the world. We are part of the Southern African Power Pool, and both in terms of trading on that market as well as on the bilateral contracts which we have with neighboring countries' utilities, how exactly those would be handled within the market, given that we can't summarily cancel those bilaterals or the political agreements which underpin them. So that was an area which received considerable attention. Then on the next slide, the day-ahead market is really about the first of the market mechanisms that would deal with the actual scheduling, and exactly how that would be achieved, described here, and how the settlements after the day would work, and the timelines associated with settlements and payments and the like. Item 10, or chapter 10, dealt with the intraday market. So this is within the day as things differ, what the timing of those would be, those transactions would be, the pricing and the general methodology which would be associated with the intraday market. Again, there are different ways of approaching the intraday market. The Southern African Power Pool does it one way, we're proposing a different way, and that is covered under chapter 10. Then getting to real time, the real-time dispatch covers then the inputs in real time to dispatch, the scheduling algorithm for that, the dispatch algorithm, I should say, the schedule reports and the dispatch instructions. And once again, this is the interface between the market operator and the system operator. Item 12, the market participant metering and reconciliation. Obviously, if you're a market participant, we need to know how much you are producing or consuming, and this chapter outlines the requirements for meter installations, data, and reconciliation afterwards. Item 13, on balancing, this is to cover the practicalities that not everything goes according to plan, and this chapter deals with the requirements of the balancing mechanism to bring the system into balance, even though suppliers and off-takers, as I said, don't produce or use exactly what they committed to do, and how those, including balancing stacks, so this would be a list of who the system operator would go to handle imbalances, how the payments would work, the pricing, and the balancing groups. On chapter 14, the settlement reports stipulates requirements for scheduling dispatch reports and system operator reports to NERSA. Item 15 then, on the financial settlements. Obviously, after the fact that there's a need for very efficient settlements of the transactions, the cash collateral requirements are very important. The market can't be left high and dry by non-payment. So exactly how that's going to work and what the two options are to deal with non-payments are described within the chapter 15. What the timelines are associated with all of the above, how queries and disputes are handled. I've spoken about non-payment, what the required credit cover is, and how the administered settlements would work. On the data and IT management, obviously critical components of this. It talks about the responsibilities of the market operator with regards to the systems and the data, the development and maintenance of procedures, and how the audits of all of the above would work. Chair, in the course of the development of the market code, I think it was identified that we need to split out the market rules out of the market code. I think we'd undertaken the development of the market code and market rules simultaneously. So we've done that and submitted the market rules separately. And again, 4 aspects to them. The first would be the market conduct rules, which would then govern how the market participants would behave, including provisions for market surveillance, information transparency, and insider trading sanctions. And again, I'd point out that this is an element where there have been many views expressed as to who exactly would be responsible for that. And I'm sure those would come through in the comments. The second would be the central purchasing agency and the conduct for the central purchasing agency within the market. It's well spelled out in the ERA, but nevertheless, it's important that we repeat it here. And then once again, a dispute resolution process. And then number 4, non-market participant balance responsible parties. So we don't want escapable charges, etc., in order to make sure that everyone makes their due responsibility, both financially, but also in terms of keeping the grid in balance. We will, we do in section 4 talk about how that would work in the case of non-market participants and what they would nevertheless be responsible for. Thank you. If we can then move to the next slide. As indicated, there were extensive comments received and inputs and contributions and proposals, which once again we sincerely appreciate. And I know my 15 minutes is coming to an end, Chairperson, so I'm not going to go through each of these columns in detail, other than to say that we have followed a rigorous process to categorize each of the comments, the hundreds received, and the inputs, and have systematically worked through them and use them to provide or to revise the market code as the evolution has taken place. So I'm going to step over slide 1 and 2, and I think that does, according to my watch, bring us to the end of the 15 minutes allocated. So, Chairperson, thank you very much, and we look forward to the deliberations and engagements this afternoon. Thank you.
Thank you very much, Mr. Etzinger. So at this stage then, I am going to invite the members of the regulator present. If they've got any questions, over to you, members, by show of hands. Mr. Mkize?
Thanks, Chairperson, and thanks, Ms. Christinger, for the presentation. Excuse me. I note that there are issues of the transition, to the fully fledged SAWIM. I was hoping that you would also talk to those if the code sufficiently addresses that aspect, and also to say from your side, what do you consider in terms of the safeguards that are there, especially with regard to municipalities, and other market participants, right? With regard to issues of debt payment, as we know that there are currently challenges in terms of debt owed by municipalities. Would that assist in any way to change that aspect? And then also, if there is any further safeguard in terms of ring fencing the market operator from the system operator, as well as the central purchasing agency. And your reflection in terms of NERSA having powers to oversee and play a role maybe in the approval or appointment of the governance bodies, like the Market Governance Committee or the Dispute Resolution Committee. And then we know that when it comes to curtailment, there is this issue of renewable energies where we are technology neutral generally. Do you foresee any situation in future where they would be some kind of being selective on the technology and therefore not maintaining technology neutrality, and how that could be affected when it comes to dealing with it? And with regard to other issues maybe that would talk to curtailment, I would appreciate maybe that you weigh in on that, as well as data transparency. If that is you feel that the codes do they does the code cover that sufficiently, or there's some additional measures that can be put in place with regard to that? And then lastly, in terms of the issues of dispute resolution, you think that is there any improvement that can be made to ensure the timely and proper resolution of complex matters in with regard to dispute, and whether you NERSA, even in that role when it comes to dispute, whether they must what role do you foresee them playing, standing at an arm's length, giving you space to deal with it, or what other alternative? Let me leave it at that at the moment. Yeah, over to you, Chairperson. Thank you.
Thank you, Mr. Mkize. I'll now call upon Madam Maseti.
Thank you, Chairperson, for the opportunity, and thanks to the presenter. The first question that I would like, I would like to start off with just looking at the practicalities around conduct pertaining to independence, because from my side, I think that is quite key given the institutional arrangement. So the first thing, therefore, that I would like to pose is how independence of the market operator guaranteed while it remains within NTCSA. How do we make sure that the market operator will act in an independent manner, given that NTCSA is playing multiple roles as the system operator, as the transmission network service provider, and as well as the market operator, just for those three roles that it will play. So I just want to understand the independence part. What kind of guarantees in these roles that you are providing to NERSA in that regard? So again, how would the regulator independently verify compliance rather than maybe relying solely on information generated by the market operator? And again, that is on independence, as we need to do enforcement of any breaches of the market conduct. And the other thing that I just want to find out, again, it's around sort of legal mechanisms that will be put in place to prevent NTCSA from effectively acting as the investigator. Remember, you have the market codes that you have proposed, and again, because the market operator must then be vigilant in the market in terms of the conduct of the participants in the market. So how do we make sure that we prevent NTCSA from acting as both the investigator as well as the decision maker in relation to market conduct breaches? How do we make sure that that conduct is prevented and we can get accurate information, integrity, and be able to, from our side, punish conduct that is genuinely and not consistent with the law? Then we come to the governance framework that you have. If you can just enlighten us, because you do have a part of the segments that you have proposed, or components where you deal with the governance. So how the proposed governance framework aligns with international best practice, where, for instance, market surveillance and regulatory enforcement are institutionally independent from day-to-day market operations. We just want to be certain about this, and that's why I would like to then check from NTC-SA, checking in other markets in other jurisdictions, these kind of institutional arrangements, and also the mechanisms that are put in place when it comes to market surveillance as well as regulatory enforcement, so that we can see whether those were successful or whether there are certain gaps, so that from our side as NERSA, we can be able to look at this carefully and make sure that it is properly customized and will be able to deal with whatever gaps or challenges that may have been encountered by those countries that you benchmarked with. Then what safeguards that you have come up with to ensure that no participant, including ESCOM or any NTC-SA affiliated company, that then receives preferential treatment when it comes to access to information or operational advantages. We just want to make sure that the market conduct rules and the code, it does have a specific upfront prohibition of this kind of situation or information that would give advantage to affiliated companies or even ESCOM, because ESCOM is, we have ESCOM holding, and NTC-SA falls within that. So how do we then make sure that they would not be able to see the information first before other participants in the market get to see this information, some form of insider information, which is one of the issues that the energy regulator should be able to prevent. And should it happen, we need to decisively punish that kind of conduct. But now, at this stage of developing these rules, how do we make sure that there are strong safeguards that are in place to avoid that preferential treatment and access to information and operational advantages? I'd like to leave it at that, but also I think what is important, as you know, that the energy regulator also is to come up with the market surveillance framework. And obviously that framework must take cue from the rules themselves, from the market rules themselves, and the specific conduct that is in the rules. And this, therefore, it takes me to a question of the sufficiency of the conduct or the adequacy of the conduct that has been identified here as the conduct that will be that should be targeted, so that by the time then we come up with the monitoring, what is it that we are monitoring, and what is it that we're going to investigate and punish, at least we know that it is things that are all part and parcel of the kind of conduct that is contained in the market conduct rules. And these are things also under market dominance or market power or market manipulation. These are things that pertain not only to excessive pricing when there's some withholding of staff, of capacity, and then it results in excessive pricing. But one of the critical issues, especially in the context of the South African market structure currently, when we move to SAWEM, is the predatory pricing below cost, knowing that that cost that is sacrificed or the profit that is sacrificed in one part, that profit by any dominant firm or a firm that has market power, not necessarily dominant, but has market power, that sacrificed profit or cost will be recovered elsewhere in whatever form, whether it is recovered through fixed cost or other legacy cost to make up for a substantially or artificially substantial energy cost that we might, for example, see. I'm just giving an example to explain the issue of the adequacy of the type of conduct that should be contained in these rules. Hence my question about the adequacy thereof. I'd like to stop here for now. Thank you.
Thank you, Madam Masidi. Just one question from my side. It's just to clarify how renewable energy curtailment will be addressed under the proposed wholesale market code. You know, given the need to maintain minimum generation levels using coal-fired stations, how will the system operator balance these operational requirements with the dispatch of renewable energy during periods of high renewable energy resource availability? So with that, then may I then invite you again, Mr. Etzinger, to respond to the questions?
Thank you very much, Chairperson. Thank you for the questions. And if I will go through the answers to them. If I happen to miss one, please forgive me. And if I could ask just to be reminded if I accidentally do miss one. The first question from Mr. Nkiza dealt with the transition to SAWEM, and as we know in the law that there is a process of evolution which is, I think, dealt with by in the following way. I think that there is a vesting contract framework as well as the wholesale tariff framework, which is currently out in a position paper format by the regulator, is really the combination of those is really intended to provide a shock absorber to the system as we move from a vertical integration into the wholesale electricity market. So the idea is that SAWEM must operate as a market, but for the protection of the current incumbents as well as to avoid market abuse. And it comes back to the later questions about predatory pricing, etc. Those vesting contract frameworks will be there. So that is how the law envisages that the transition will be handled, and that is how we are currently structured. Again, so it's not only the market code, but that would need to be read then in conjunction with all the work that's happening on the vesting side, etc., which outside of the market would provide the necessary mechanisms and comfort and assurances that go through that. In terms of municipalities, yes, this is a vexing question, Chairperson, as to how municipalities which are not in good financial condition at the moment would participate in the market. And the position that has been taken is to say that the market can unfortunately not absorb that risk. We would need other mechanisms within the state to assist municipalities to become financially viable and to reach a point where they would be able to participate in the market without subjecting the market to risks. Having said that, I can indicate that this is very much part of the work around the unbundling process of Eskom, which is being led by government, and that is a key aspect of this. So the municipal financial state, their ability to participate in the market, and their non-ability currently in certain instances to make their monthly payments for electricity to the Eskom group. So a critical issue, but from the market, unfortunately, we have to stand firm. We won't be able to have any ability to absorb non-payment from municipalities or any other participant within the market. In terms of the appointment of the members to key positions, and the question was whether NERSA would have yes. So the proposal is that NERSA would be consulted on those appointments. So we certainly would want to do that in conjunction with NERSA. Question 5 in my notes relates to whether we would go for technology, whether we'd be technology neutral or not. And I think that this actually raises a very interesting point about how the market forces would intersect with the integrated resource plan, which does have particular technologies and particular megawatts to be achieved at a certain time. Ultimately, what the market potentially would require, and as covered in law, actually not through the market itself, but through the central purchasing agency, would be to ensure that there's adequacy and security of supply, and that there would potentially be auctions of either a form of a generation to supply specific outputs, or conceivably particular technology itself. So in terms of that, there are different mechanisms, and it would ultimately, we'll see how that develops over time. But other than to say that over time, I think it is, if you read the law, it appears to be that we'll move away from a prescribed technology megawatts to be achieved in each year, more to an output type. So one may, for example, put out an auction for mid-merit plant or the like, or peakers, rather than say they have to be open cycle or closed cycle gas turbines, with these specifications. So the idea would be to keep it open and rather talk about what the contribution of those technologies would be. But we don't want to land ourselves up in the same situation as certain other jurisdictions where we just say, well, the market will provide, and then it doesn't. So the law clearly indicates that the central purchasing agency would need to play that role actively. Then in terms of 6 on curtailment, yes, this has come up twice on the questions, and yes, so the market code does deal with that. The market, there are 2 forms of curtailment. One, there's congestion curtailment, where the grid is simply congested and cannot evacuate the power from a particular player. And there is the, let's call it a frequency or a system-wide curtailment, which is what we are currently undertaking within NTCSA on a daily basis, which is really where there's simply just too much generation on the overall system, and we're needing to cut back on generators in order to deal with that. Again, I think the theme of international experience and best practice has come up in other areas. So let me also just link it here and say that this is a common issue and around the world at the moment, and you can, in jurisdictions such as Europe and Australia and the like, see that they're needing to do extensive curtailment in order to keep the system in balance. But ultimately, what rules will be the system operator? The system operator must keep the frequency going, and we can do all the work we like on the market operator, and of course there's rules and contracts and all the rest of it. But we as a system operator will keep the system from a blackout, and for that reason curtailment will happen. And the compensation mechanisms, as they may not appear or may not apply, will depend on various aspects. Once again, whether it's congestion curtailment, whether it's system-wide curtailment, but yes, it certainly is explicitly dealt with. Then, in terms of dispute resolution, yes, the idea would certainly be to resolve disputes very promptly. This has to be part of the market ethos which we are going through. So fully agree with the intention and the sentiment about that. It would be most efficient for the market operator to, as far as possible, deal with disputes itself. It would, particularly when the disputes aren't with the market operator, if there's other disputes which market operator can let them. Having said that, I think it's important that NERSA have oversight of that, and NERSA would have all the available data. So it's not that the market operator would sit with data, and NERSA would want it. The whole idea of what we'd want to achieve is that this information would be available to NERSA. There would, of course, be reporting to NERSA of the outcome of disputes, of the statistics around them. If that doesn't work, again, then we'd make necessary changes to ensure that it'd be efficient, but it has to. In the same way that we'd have daily settlements and the like, down to hourly settlements, the disputes has to be quickly and promptly dealt with for an efficient market. If I can then move on to the questions posed by Ms. Massetti, then on the practicalities of conducting independence, and our independence will be guaranteed while in NTCSA. In addition to now the market code, as I've indicated, that there's the wholesale tariff framework and there's the vesting contract framework. Another critical piece of the puzzle is the conditions attached to the market license, which market operator license, which NERSA have issued, and there are stringent conditions attached within those. Within the conditions, which deal with aspects of independence, and this goes all the way from independence of the information systems. We need a separate location for staff. There cannot be any let's say cross-subsidization. So the financial systems, the IT, once again, the IT systems and financial systems must all be completely ring-fenced. So that is the measure that we are currently using, and that is the benchmark, I think, which has been set by NERSA, which we are working very hard to achieve at the moment, and those conditions have been recently received. We received the draft conditions towards the end of last year, so we're not waiting. And aspects such as own facility for the staff with a separate access, all of that is part of it, and all of that is what we're working on at the moment. There's a question around how NERSA would ensure compliance rather than rely on information supplied by the market operator. And I think here another important principle would be that as far as possible, and if there's any exceptions, then we would need to explain why, but it's very important that NERSA have access to all the information. So it's not that we as the market operator should be playing any form of sifting or processing, etc. That must be it. NERSA must have all the information in order to fulfill that role, which we fully respect. Illegal mechanisms to prevent the NTCSA being both the sort of player and referee, or the investigator and the like. Again, these are spelt out in the license conditions, and we'll fulfill those if there is a need at any stage to tighten those. Of course, as we've indicated at the start of the hearing, as far as the evolution, if anything's not working, I'm sure that it would be addressed. But at this stage, there are extensive steps that are prescribed in the conditions, which we will. Then, in terms of international best practices on proposed governance frameworks, we have certainly taken advice on global best practice from international advisors on this one, and we hope that we've, in terms of what we're putting forward, reflects international best practice. But typically, what is found is that over time, there's certainly separation of the market operator and the system operator, not in all cases, but that does seem in jurisdictions such as Europe to be the ultimate intention. What's most important for us, we believe, Chairperson, is that in terms of within NTCSA is to separate the central purchasing agency from a clear potential conflict of interest. The central purchasing agency will trade into the market, and for that reason, there cannot be any overlap, any working together. Whereas I think between the market operator and the system operator, at least initially, it'll be advisable that there be some form of cooperation between those two, because once again, that they deal with two sides of the same coin, and we don't want to plunge the country into darkness unintentionally. So ultimately, the best practice in 25 years down the line, as we've seen in Europe and the US, there would be separation, but at this stage, they will both remain within NTCSA. For that matter, the law also prescribes at this point, Chair, that ultimately the transmission system operator would consist of those four businesses, being the transmitter, the central purchasing agency, the system operator, the market operators. So one can speculate how in future the evolution will happen, but certainly as far as the law is concerned, we understand that their businesses have to be ring-fenced, but they would still remain under as part of the NTCSA and later as part of the TSO within a period of 5 years of the signing, which gives us about 3.5 years to establish the TSO with all of these. Then, Chair, moving on, coming to safeguards that participants mustn't receive preferential treatment to information. Yes, critical. Again, an aspect that's covered within the license conditions, and it's both in terms of what information is given as well as the timing. One must make sure that one party, including the incumbents, cannot be given information to market before others. I think that's clear, and that once again comes down to the separation of the information systems and the portals and the like of the market operator from the current architecture of IT within the Eskom group. So this does require a substantial amount of work. There is a lot of integration at the moment, which the IT departments on both sides and for the group, also thank the Eskom group, they understand this and they're working together with us to get that separation going. But certainly the point well taken, and important that be achieved as soon as possible. I think that then, Chair, in terms of the question around the predatory pricing, just once again, very important that the vesting contract framework initially needs to provide that. So that will give basically a complete disincentive. So how the vesting contracts would work would be for if the incumbent, for example, decides to undercut the price, ultimately it won't serve the process. That's actually brought then back to the let me start. If that would be in the case of inflated prices, I think if there is abuse of the market, again, the market surveillance units, Chair, is there to pick it up, and we'd make sure that that is dealt with through that particular mechanism. Once again, I think there's different opinions as to whether the MSU, market surveillance unit, should sit within the market operator itself or be part of the regulator. And I think that ultimately, I think that there are different parts of surveillance that would be undertaken by both. I think the market must self-police to the extent possible, but then there must be oversight from the regulator as well. So I think that both are necessary. And then, Mr. Majola, to your question around the renewables and the curtailment, once again, this is currently an issue which is receiving prominent attention in the media, and this is a matter that is for the Central Purchasing Agency. So that the Central Purchasing Agency currently has contracts with approximately 120 IPPs, and the curtailment which is being undertaken by the system operator of those IPPs from time to time, not all at the same time, obviously, but to the extent necessary, is then sorted according to the 20-year power purchase agreements with each of those. So the law made provision for, and we've made provision for as well, that the CPA will be once again trading that power into the market. If there is an instruction from the system operator to curtail those, then the curtailment payments would be made then once again by the CPA according to those contracts. I come back to the point previously, Chair, that when it comes to the curtailment, and this would need to be equitably done across all renewables, but there would be different rules that would be applied obviously to those trading in the market, and it comes back to as well as those either participating in the market itself or through bilateral contracts. So this does become quite a complex picture, and what's important is that we must achieve an equitable solution, making sure that there's no abuse one particular party. And also we need to differentiate between congestion curtailment and frequency curtailment, Chair. So that we can, Chair, we can propose to put that down in a document. We following this to explain the thinking around the curtailment, but it certainly is a contentious matter, which once again involves the market operator, but also the CPA as well. Chair, I hope I've answered the questions. Hope I haven't missed anything, but hope those answers suffice. Thank you, Chair.
Thank you very much, Mr. Ettinger. I think we need to move on now in the interest of time. So I'm now going to call upon Mr. Johnson from Exionix Pty Limited. Mr. Johnson. And please switch on your camera, Mr. Johnson, because we're going to be taking the oath.
Yeah.
All right, just let me know when your camera is on, because it's going to make things easier for me. All right, thank you.
So,
Oh, thank you very much. So, Mr. Johnson, please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
yes, Chairperson.
For the record, please state your name, organization, and designation.
I am Bulelani Nolan Johnson, founder and managing director of Exionix, a 90% Black-owned energy and technology venture based in Kabeja, formerly known as Port Elizabeth.
Thank you. Please remember to forward your presentation to public hearings at nesa.org.za. You may proceed with the presentation. You've got 15 minutes.
But can I share my screen, please? Okay.
Yes, you may show the screen.
Good afternoon, Chairperson and members of the committee. Like I've stated, I am Bulelani Nolan Johnson, founder and managing director of Exionix, which is a 90% Black-owned energy technology venture based in Kabeja. We commend the National Energy Regulator of South Africa and the NTCSA on the transition to a competitive electricity market. However, there is a critical execution gap in the current market code. Financial wheeling contracts are static, while grid physics are highly dynamic. Under the new rules, licensed generators and traders must act as balance are responsible parties when sudden cloud cover hits the Northern Cape or transmission constraints force curtailment. These balance responsible parties will face ruinous schedule deviation penalties. The South African market currently lacks the digital machine-to-machine coordination layer required to prevent this. So, to solve this friction, we developed Flux Agent. Flux Agent is an asset-light, API-driven virtual power plant and demand response layer. We do not build new power plants, and we do not buy or sell electricity as a principle. We provide the software intelligence to licensed traders. Instead of relying on expensive hardware installations, our software treats heavy industry as a flexible grid asset. By computing a live grid stress index, The platform autonomously throttles down non-essential industrial cycles during grid strain and shifts them to absorb surplus energy when localized renewables peak, which seamlessly orchestrates diverse loads from municipal water pumps at Rand Water and mining compressors at Sishan to agricultural cold chains in Siras and electric bus depots like Golden Arrow. So this intelligence is vital for optimizing the economics of wheeling. Eskom's automated virtual wheeling platform calculates monthly refunds based on strict time of use periods using a lower off rule. As shown on the screen, the refund is capped at the lower of the energy consumed or the energy wheeled. If an off-taker's consumption does not perfectly match the independent power producer's generation spike within that exact sub-hourly block, the financial value is permanently lost. Flux Agent programmatically pins corporate consumption directly to generation spikes, maximizing that minimum function and ensuring zero wheeling value is left on the table. We are not presenting a concept today. Flux Agent's core predictive architecture is already fully deployed on our servers. We are currently running the platform in shadow baseline mode, processing 9 years of actual historical Eskom telemetry, specifically unplanned and planned capacity loss factors, paired with high-resolution regional weather data. To ensure absolute data provenance and mathematical integrity for the system operator, our models are trained and scored strictly on native hourly observations to avoid interpolation matrix flattery. We are fully prepared to transition this shadow architecture into active live grid pilot environments. To ensure the South African wholesale SAWEM framework functions efficiently, we submit 3 specific recommendations for the final market code. First, the National Energy Regulator of South Africa must mandate that the market operator provides open APIs for balance responsible parties to submit their day-ahead and 6-hourly intraday redeclarations programmatically rather than manually. Secondly, the code must enforce strict service level agreements for the publication of low latency network constrained signals, allowing software providers to adjust predictive models in real time. Thirdly, or finally, the market rules must explicitly define how a balanced responsible party can legally aggregate decentralized flexible loads across different municipal distribution boundaries into a single scheduling profile. Allowing autonomous agent software to dynamically balance localized loads will drastically reduce grid stabilization costs for the future transmission system operator. I appreciate everyone's time and leadership in the transition. And I'm done.
Thank you very much, Mr. Johnson, for your presentation. I will now give this opportunity to the members of the regulator if they've got any questions. Over to you, members, by show of hands, if you've got questions. Yes, Mr. Mkhize.
Thank you, Chairperson, and thanks, Mr. Johnson. maybe this goes to all the soon-to-be presenters in terms of maybe deriving most benefit out of this process. I understand that there have been prior consultations and not one, and I think it's going to be important to when the presenters are on the platform to maybe kind of deal with matters that they've taken into consideration that remain concerns, even out of those consultations at a technical level, or what has emerged in these consultations that then results in them having concerns. And maybe if these concerns, they are residual concerns, they remain, they maybe proffer some kind of ways of mitigating or addressing those concerns. I would really appreciate if that could be done in that manner, especially for those that have participated. You talk of the VPPs, and your concern around the balanced responsible parties getting the shorter end of the stick. The question is this, in this whole thing, what does it leave the system now in terms of transitioning, noting that when we're talking of VPPs at this juncture, it's not something that is in the mainstream. How do you, well, if you consider the counter arguments and how to address those, what is your stance around maybe a phasing in that will be fair to all the players? Because we're not looking at only one player here. We do understand that there are each player's got vested interest and it is within their right to advance that. But how do you then envisage that this be handled? In this whole process, what does it leave the end user with at the end of the day? Because yes, well, the transformation of this market is important, or the creation of the market is important, but at the same time, we also need to bear in mind that there's also an outcry of the high electricity prices, and then to say, how do you see this assisting at the end of the day? And then from my side, because there are also, you're talking of VPPs, there are also a lot of things that are moving at the same time. And I think it's also something that NTSSA should also consider. We talked of vesting contracts to say how sufficiently are they aligned with this, or how best do you think that they need to be aligned, noting that the market code is under development, as well as the vesting contracts and transitional matters. And I think the same with the issue of VPPs. How do you think that there should be alignment in the development of all this and the transitioning thereof? What early warning, reporting, and escalating mechanism should be introduced to manage participant default risk? I would say that applies to NTSSA, but also when it comes to you, what kind of warning mechanism should they be in place to assist in terms of not leaving the BRPs worse off? Let me leave it at that. Thank you.
Thank you, Mr. Mkize. And now I'll call upon Madam Maseti.
Thank you, Chairperson, and thank you to Mr. Johnson for the presentation. Chair, I'm unable to get to the slide, but this is the last slide where there are recommendations, regulatory recommendations. So I was trying to get to that. There are two last recommendations that are made, and my questions relate to those two recommendations. To start off with, just to put the context of what we are dealing with today, all that we are concerned about today is the conduct of the parties in the market. So we are making sure that the rules that are there to regulate the actions and the conduct of the behavior are proper and will target every behavior that we need to target, to the extent that the behavior will undermine competition and will cause harm. And that's all that we're here for. Now, I want to understand with the two proposals that you made, one around rules for cross municipal aggregation. What conduct are we targeting there? And what is the theory of harm that we're supposed to then tackle with the rules here? Because all we're doing here, we need to identify, make sure that the conduct that is there and the rules are targeting that conduct so that it does not undermine the fairness in the market, the way that the market should be functioning. That's all that we're all about here. So if you're now talking about we must come up with a cross municipal, for aggregation, I can't see that. I was hoping that it will be put out there so that I can be in a position to make reference to it. Okay, let's see. To define rules for cross-municipal flexible load aggregation. Can you tell us what is that for? When you state the rationale, please state why that should be something that we must concern ourselves about insofar as the conduct of the participants are concerned. Why should we be concerned about? What conduct are we targeting? What economic problem are we targeting so that then the players can correct? And if they don't correct, we punish them by invoking the rules. And that's the first question. The second one, again, is to provide the real-time settlement data for predictive models. Can you also just indicate along the same lines so that we understand what conduct are we targeting there? And if that is not done, what you are proposing, therefore, there is this possible harm that will happen in the market. That's how we're supposed to be looking at this. Can you tell us then, as you propose these things, what is the possible harm if the things that you are proposing are not done, so that we can understand the behavior that we should prevent or punish? Thank you.
Thank you, Madam Maseti. So I will now call upon Mr. Johnson to give a response to the questions asked. Over to you, Mr. Johnson.
Okay, so as I've stated that Exynix operates strictly as a software as a service and a technology infrastructure provider. So Flux Agent is designed to predict original renewable energy surpluses and dynamically match them against diverse, flexible commercial and industrial loads. Crucially, Flux Agent never takes legal title to electricity. The platform does not buy, sell, or retail electricity as a principal broker. It functions exclusively as an independent cloud-based optimization layer, sitting on top of licensed operations. It doesn't make other decisions. It optimizes for the licensed trader. Fox agent does not rely on a single asset class. Instead, the platform derives its systemic value by algorithmically stacking highly diverse industrial, commercial, and agricultural load profiles to maximize grid balancing efficiency. And that is all for me, Mr. Chairperson.
Thank you very much, Mr. Johnson. We're now going to go on then to the next presentation from ESCOM. I see there's 3 people here. It's Madam Moodley, Mr. Chipala, and Mr. Sundanam. So can I ask you to switch on your cameras, ESCOM? And just let.
Good afternoon, Chair. Our camera is on. Can you see us?
All right, I'll find you. I can see you, and thank you very much. I see you're all in one room. So I'm then going to ask you one by one, or maybe all of you to raise your right hand and affirm the following. So I'm going to ask the 3 of you to raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth? Response?
Yes.
Yes.
Yes. Chair.
So for the record, one by one, please state your name, organization, and designation.
Samantha Motley, ESCOM Regulation.
Motenda Chipala, ESCOM Distribution.
Kapil Suknandan, ESCOM Generation, Production and Sales.
Thank you. Please remember to forward your presentation to public hearings at nesa.org.za. You may proceed with your 15-minute presentation. Thank you.
Okay, Chair, I'm sharing my presentation. Just give me a heads up that you can see it, Chair.
Yes, thank you. I can see it. Thank you.
Right. I thank Chair and NERSA for the opportunity. ESCOM supports the reforms, and ESCOM is looking forward to being an active market participant in the upcoming SAWEM market. Our comments today, we must be viewed as a way of improving the process, as a way of improving the market code. Thank you. The 3 of us will present. I'll present first. I'll touch a bit on the technical foundations. So what we are saying here, Chair, is that we believe what we were supposed to have first is we were supposed to first have what is called a market design paper. And then once we conclude on the market design paper, we were supposed to conduct simulations. And then once we are done with those simulations, we were then supposed to select the least cost path in terms of the formulations that we want to see in the market code. This process was followed in Australia. This process was followed in the UK. We can provide you the details, Chair, if they're required later. But this process has not been followed in South Africa. So what we are actually saying here is that our market code in South Africa is not based on a solid firm foundation. That foundation being a market design paper, which is missing, and market simulations that are missing, Chair. So this is the message from this slide. So to give an example, Chair, we support the market code, and then we are saying 80% of the market code is correct, but they are missing, there's details that are missing. For example, the outcome of the market code is going to be something like balancing penalties. So if your forecasting has a particular level of error above 5%, you're going to see a balancing penalties. And then we know those balancing penalties are going to be excessive. but there's no mechanism for entities like ESCOM distribution and municipalities to pass this balancing costs, to customers. We don't know what to do with those balancing penalties, So the SAWEM is going to penalize us because our focus cannot be 100% correct. It can be as best as it can be, but there's definitely going to be penalties, but we don't know what to do with those penalties. To give a proxy, Chair, of a mechanism that was developed in the NMD for the NMD rules. And NMD is a proxy for forecasting. So we know that municipalities tend to get their NMDs wrong and they get penalties. And NERSA has a document called the NMD rules. And in there, it talks about if a municipality exceeds its NMDs, what is supposed to happen in terms of costing, and then how is that cost supposed to be passed on from ESCOM and ultimately end with the municipalities. And then the municipalities will obviously internalize those costs and pass them to the customers. But with the SAWEM, there's no mechanism there's no mechanism for distributors at all to handle the penalties that will come from the balancing market. So we have simulated this. We think this can be in excess of a worst case scenario if your forecast is wrong, can be in excess of 2 billion rand a year, Chair. So what we're asking of NERSA to do is to suspend the balancing mechanism until such time that NERSA has come up with a pass-through mechanism for balancing penalties, Chair. Internally, NTSA has agreed to suspend the balancing mechanism, the balancing penalties in a simulation phase. So this is what we are saying here, Chair. Number two, we are saying this market of ours is not informed by any simulations at all. ESCOM has been asking for these simulations in almost all the public forums, but we have seen none. I have seen no simulation at all. So we are asking for these simulations to inform things like the market cap, We know in the Ofgem in the UK, they've got a senior manager. His role is only to look and quantify what the market cap should be. And that market cap is based on simulations. And those simulations consider other impacts, the ability to recover stranded costs, if you are an incumbent generator, etc. But in a South African context, there is nothing at all. No simulations were done at all to inform our positions of how the market should look like. So what we're asking for, Chair, particularly for things like curtailment, we are asking for you to pause on the compensation for curtailment until that mechanism is informed by market simulations so that we choose the least regret path, So the path that is currently being chosen, we don't know what it is based on at all, but I'll touch on the curtailment issues in the next slide as well. So, Chair, what we are saying is that market design is about making decisions around issues such as how do you recover stranded costs? How do you design a transition capacity remuneration mechanism? How do you include locational signals in your market design, in your pricing, etc.? But in a South African context, all of that is missing. So we're just wondering what this market design of ours is based on, So we don't have a policy paper that informs us that we should have locational signals or no locational signals in South Africa. So we don't know how that decision was arrived at. We don't know at all. There's no policy document. There's no EPP. There's nothing that says in South Africa you will have locational signals or no locational signals at all. So and that was supposed to come from a market design paper, but that is absent. So what we're asking for is maybe for a few of these issues, please pause them, particularly the curtailment aspects, look at the market design issues, choose the least regret path for ESCOM, and not for ESCOM, for the industry, and go with that least regret path direction. I try to be quick. So on this slide, we're trying to summarize the whole curtailment issue, Chair. curtailment is a very complicated concept. Even such subject matter experts in ESCOM don't understand it. Some of us, at least, we have met, we've discussed, even subject matter experts in NTCSA, and we just don't understand it. But what we know is that the burden of curtailment is going to increase, Chair. It's going to increase because during the day you've got excess renewable generation from your solar plants. This excess renewable generation from your solar plants reducing your residual load. So your residual load, your load on the system during the day is very minimal, while at the same time you need to keep your coal stations on because you are going to need those coal stations in the evening. But in South Africa, what we have decided is that those generators that you are curtailing, we are going to compensate them. So the question we are asking is, what policy is that? You know, we know overseas they get compensated because there are policies directed and incentivizing renewable energy resources, and then it's explicitly said that if to incentivize your variable renewable energy resources, when you curtail them, compensate them. If you are not using a compensation mechanism, then there are instruments that they use, like two-way contracts for differences. But in a South African context, what policy is guiding this? What did we base this decision on? So there's no government policy that says you use curtailment to incentivize renewable resources in South Africa. That policy, I have not seen it. In addition, we have not done any studies to quantify the least regret path in this space, Chair. So all we are saying is we think maybe we could have failed. We should have done the market design issues first, and we should have done the market simulation first, and then choose the path of least regret. We know the NTCSA has said curtailment is going to increase to reach 7 gigawatts by 2030. That statement is on their website. And we know today curtailment is in excess of 2 billion rand. So if we go to 7 gigawatts, curtailment is going to be in excess of 10 billion rand. And we know the market code is saying that cost must be socialized. It must be passed to our aunties and our gogos. And we don't understand why the risk is being taken by our aunties and our gogos and not by the incumbent generators, Chair. So if you look at the other markets, Chair, I'll give a brief example. If you go to PJM, if you go to Chile, Caiso, and ERCOT, those are central markets. On my screen, those are central markets, central dispatch markets. Their pricing is nodal based, locational marginal pricing based, and they don't compensate for curtailment. Instead, when the grid is constrained, the price in that node goes to zero or goes to negative, and the generator automatically gets off the grid. But what we're not understanding is, why is South Africa a central dispatch regime, but compensating for curtailment, which is not aligning to how other markets have done it. What we know is the markets that are actually compensating for curtailment are the markets that are decentralized. So those are some of the issues, including we don't support how debt must be socialized as proposed in the code. Those that don't pay their costs, they must be penalized. Sufficient guarantees must be raised. Also, there's the whole issue of opening up the market to embedded generation that is sitting within the municipal space. We support that, but we say it should be based on a readiness approach. If the municipality cannot see the flows, then it's just going to create chaos on the network. So in summary, those are the issues. Thank you.
I will be taking you, good afternoon to the members of the Energy Regulator. I will be taking you through the ESCOM legal comments. At every market code workshop, we requested the due diligence. We were assured that it would be made available. Despite repeated requests, ESCOM did not receive the legal due diligence. As of last week, I again asked the NTCSA, the market operator, and NECOM to please share the document We did not receive the document. Be that as it may, we've put together a few comments on the market code, and these are largely based on the foundational legal principle that higher level laws take precedent over lower level laws. Next. So the Market Governing Committee is the administrative authority for the market code. Our view is that NERSA is the administrative authority for the ERA. The Market Governing Committee is an advisory forum in terms of Section 5 of the ERA. It is similar to the GCAC. NERSA is the decision-making body and the administrative authority for taking administrative action. This provision contradicts the ERA, NERA, interpretation of statutes, PAJA, and the Concord decisions. The Market Governing Committee establishes prices. Other than the exceptions by legislation, NERSA has the mandate in law for approving tariffs and prices. It is unclear to us how a market governing committee can establish prices. This contradicts the ERA. Generators above 100 kilowatts embedded in a customer network that is connected to HV and MV may apply to be a market participant. Schedule 2 states that a generator embedded in a customer network without a connection point provides a supply to the customer. It does not export into the grids. Our networks were never designed to evacuate this sort of power. In a meeting recently between Transmission Grid Planning, Distribution, and NERSA, Transmission Grid Planning was saying to us that distributors cannot allow generators to indiscriminately connect onto the grid because it has a knock-on impact on transmission, and it could cause the collapse of the grid. The connection to the network is subject to capacity availability and costs. This provision is unlawful. It contradicts Schedule 2. It's irrational because the customer or the generator doesn't have a connection point to the grid. It's irresponsible. It's creating expectations in the industry, and it's placing transmission and distribution networks at risk, and it's going to result in chaos in the industry. Generators can trade during commissioning. As you are aware, the NSPs are liable for what happens on the grid. There is a presumption in Section 25 of the ERA that says we are negligent if there's any damage or injury. If this is allowed, then the market operator and NERSA must carry the liability for any damage or injury caused. Resellers are customers in the SAWEB. This contradicts the provisions of the resellers guideline, the ERA Schedule 2, the MFMA, and the service delivery agreement. NSPs must follow any suspension or termination order approved by the Market Governing Committee. This contradicts Section 21.5 of the ERA. We can only suspend and terminate a customer under specific circumstances. The customer has failed to pay an account. The customer is insolvent, the customer has not entered into an agreement with us or breached an agreement. If a customer has not breached any of the distributor's requirements, we have no legal basis to terminate or suspend the customer. This provision contradicts the ERA. NSPs must facilitate any data queries, settlements, and disputes. We do not agree with this because we do settlement queries, disputes, etc. in terms of the ERA, POPIA, and PIA. This provision must be aligned to the law. Market participants, we must make available information to the MSU as they require. Again, we follow the law. We will make information available in terms of POPIA and PIA. A modification approved as urgent could have retrospective effect. Generally, administrative actions cannot be made retrospectively if it affects rights or affects someone adversely. We want clarity on how this will apply to NERSA decisions. Then we have the market operator encroaches on other legislative mandates. The ERA mandated the SO to develop the balancing mechanism, not the market operator. The Energy Act and the ERA places security of supply with the DE minister, not the market operator. The SOs and NSPs have the responsibility for safety, security, and reliability of supply, not the market operator. It is NERSA's mandate to promote short-term and long-term interests of customers in South Africa with regard to price, quality, reliability, security of supply, not the market operator. It is NERSA's role to ensure fair treatment in trading, bilateral and SAWEM across the NIPS, not the market operator. It is the Competition Commission's legislative mandate to ensure fair competition in the country, not the market operator. The ERA gave the market operator a specific mandate: develop a trading mechanism, develop trading platforms, develop a market code and market rules. The market code exceeds the legislative mandate in the market. The market operator exceeds the legislative mandate in the market code. International trading. The ERA is very specific. It says the CPA will undertake imports for the customers within the Republic, and it will export in line with the country's obligations. We have repeatedly asked the NTCSA and the market operator, which provision in the ERA allows other parties to do this? We have not received any response, but NTCSA has given letters of support to people applying for import and export licenses. This also contradicts the Constitution of South Africa. Regional rules do not override the sovereignty of a state or the laws of a country. Our Constitution says, Section 231, for something to become legally binding in our country, it must be adopted into our national legislation. Again, we ask the question, which provision in the ERA allows for this? NERSA can appoint a default retailer and designate a tariff. Once NERSA makes a decision on a supply area, it's an administrative action. Once NERSA approves a tariff, it's an administrative action. NERSA would have to go to court to revoke its own decision. We also don't understand how NERSA designates a tariff. Our understanding has always been that NERSA approves a tariff on application. We don't understand this. In addition, it doesn't deal with how would you deal with municipal surcharges, etc., when you designate another retailer. Next slide. BRPs, our view is that a balanced responsible party is not obliged to be a market participant. We also state that Section 7 and 9 of the ERA, which deals with licensing and registration, places no requirement on anyone to register with a market operator. The BRPs must, however, comply with the system operator balancing mechanism. There's a difference between NERSA codes and market code, and they have different mandates. If the market operator wants to change something that's mandated in the NERSA codes, it must approach the GCAC and make a change. But the market code should only deal with market provisions. The market code has an indefinite duration. We disagree with this.
Excuse me, Madam Moodley, can I ask you to wrap up now? Because I think you are now beyond 15 minutes.
Yes, Chair, I will just wrap up. In its current form, we cannot comply with the market code because certain critical provisions are contrary to the law. NERSA also cannot find us to be non-compliant because we complied with the law, the market code didn't. We were given strict instructions by our ESCOM leadership. If we are to raise concerns, we must provide solutions to those concerns. There are two solutions to the issues we've raised. One, this market code must be revised to comply with the law, or two, the laws must be revised so the market code can become compliant. We propose that this market code be further workshopped and sent back to the industry. We also require the legal due diligence. ESCOM requires a legally compliant market code. NERSA must make decisions in compliance with the law, and we reserve our right to take this matter on review. Thank you.
Thanks. Thanks for eating my time, colleagues. Thank you, Chairperson. I'm presenting ESCOM Generation's formal comments on the Sovereign Market Code. Let me open by making our position unambiguous. ESCOM Generation supports the establishment of the South African wholesale electricity market as a foundational reform for the country's energy transition. We are committed to enabling a successful go live. Our comments offered in a constructive spirit to strengthen the reform, not to delay it. Our message to the regulator is that the market code cannot be assessed in isolation. It is one of the several interdependent instruments alongside vesting contract framework, the wholesale tariff methodology, the trading rules, and the CPA conduct rules. All these mechanisms cannot be reviewed in isolation as they are codependent. From a regulatory standpoint, our primary concern is the market implementation must be consistent with financial stability and system security. As currently drafted, several provisions introduce material risk where settlement, dispatch, and governance arrangement remain unresolved. The dispute resolution arrangement, in particular, the lack of independence and legal enforceability needed for commercial dispute. The code is largely agnostic to system adequacy risk and the unique operational and contractual risk carried by the coal fleet. Our request to the regulator is therefore a conditional one. The code should be approved and implemented only once readiness has been demonstrated, meaning validated systems, clear accountability, and defined implementation safeguards. There must be a simplified technology neutral capacity remuneration mechanism targeted at flexible dispatchable capacity for midday to evening ramp to hold systems secure while the market matures. Slide 2. We set out 4 priority risks we believe warrant direct regulatory attention before code is approved. Firstly, financial risk, uncertainty in settlement design, the timing of payments, treatment of penalties, and recovery mechanisms can create instability in cash flow and credit exposure across all market participants. For a market of this scale, there is systemic concern and it needs clear tested rules before go live. Second, operational risk, where dispatch instructions are misaligned with plant technical limits and system requirement, participants may be unable to deliver on their obligations. That exposes them to unintended penalties and introduces undesired risk to the system operations. Market rules must be reconciled with physical realities of the fleet. Third, curtailment costs and cost allocation risk. I think our colleagues covered that in detail. Fourth, commercial and contractual risk. The treatment of existing PPA obligations, hedging arrangements, capacity recovery mechanisms remain unresolved. Until it's settled, both cost recovery and investment certainty are at risk. We ask that these four risks be treated as gating items, matters to be resolved as conditions of approval rather than deferred to post-implementation. Detailed modeling will be required to be conducted to quantify the overall system risks, as it's strongly advised that the regulator do this. Slide 3, on my last slide to close, there are 5 recommendations through which we believe the regulator can grant approval while protecting regulatory certainty and system security. Each is framed as a safeguard, and together they form a readiness test the market should meet before financial exposure begins. First, phased implementation. Allow full testing of scheduling, dispatch, settlement processes before any party is financially exposed, and to do so in a way that respects Eskom's generation's existing contractual obligations. Second, independent validation of settlement systems. Payment flows, dispute resolution processes, and data integrity should be verified by independent party rather than self-certified. Third, transparency and disclosure of curtailment and balancing costs so that the regulator has information it needs for efficient oversight and for future policy decisions. Fourth, alignment of market rules with physical system constraints to ensure dispatch is generally feasible and participants are not placed in unintended non-compliance. Fifth, clear definition of roles, responsibilities, and decision-making authority across the market operator, system operator, and regulatory structures, because ambiguity in accountability is a risk in itself. If these 5 safeguards are met, Eskom Generation is ready to support the market with confidence. Thank you. Thank you for your time.
Thank you, Chair.
Thank you, Chair.
Thank you very much to the Eskom team. I will now open it up for the members of the regulator if they've got any questions. Members? Yes, Mr. Mkize.
Thanks, Chairperson, and thanks to the Eskom team for the presentation. Yeah, I note the issues, you know, but I'm a bit concerned with the maybe some form of rigidity on some of the things in terms of. I just like to get from your side, as Eskom, to start off with, are you taking yourself into the future and looking at this, or you are static as now and saying this is how it should be? Because I'm thinking, if you don't do the simulation, say for example, isn't there a way of having the code, and then the simulation is part and parcel of what then transpires being guided by the code? And then, because we're looking here at the timelines, and then it's something that you use to refine and implement. I just want to get that kind of clarity. And you are saying that you from your side, for example, you're talking of POPIA Act and other acts in terms of sharing of information. But information is still being shared in other platforms and other systems with this act in place, with the consent of those who are participating, to give permission to access and the use or distribution of that kind of information within certain confines of the law. Why can't the same apply where you are actually proposing solutions within the ambit of the law by way of harmonizing these different pieces of legislation with the understanding that the first part or first take is harmonized without a need to amend legislation, and then amending legislation becomes then the second option to harmonize. And in terms of you're saying that the code should be approved only once readiness has been established. I'd like to understand this portion. Are you not putting us in a chicken and egg situation where one would rather say you look at the code being overarching, and then as you move you approve it and work within that framework, because it's a broader framework. That's how I look at it. Yes, it's not a framework as such being a code, but you are operating within that. And I just want to get clarity there. And also, you're talking of a market code vis-a-vis a NERSA code. Isn't the code giving enough? It's a question for me to say, is to have enough space to work within the parameters? Because my understanding, even when you talked of NERSA regulating, and then the MGC being in contravention of the laws, isn't it that NERSA will the MGC will operate within the confines of what NERSA has determined in terms of the prices and everything? Even when one looks at the alignment of the market code with the vesting, working on the vesting contracts framework, I'd like to understand if you can just reflect on that and provide some kind of clarity. And then lastly, from my side, is to say, you talk of the legal due diligence in terms of what we have done and the harmonization, and I'm not getting clear as to where is the point of disagreement. If you can maybe when you present, you submitting your written comments further, just to indicate in terms of the consultations before coming here. And I must thank you anyway for also alluding to some of what transpired during those consultations. But to be clear as to what are really the point of difference or contention, other than something has not been done. If you've done something, what is your firm proposal around that? Other than to spot the problem in the current setup, how can it be that problem be addressed? So sorry for taking your time, Chairperson. With regard to the curtailment, I think the curtailment, you're talking of the compensation still sitting at 4%. And what I didn't get clarity regarding how you want this to be socialized, because you say from your side, because you're saying that it goes to be paid by our grannies and all bus, but that happens even in the current setting. I just want to understand why the difference, and how then to make sure that it is fair and just. I'll leave it at that. Thank you.
Thank you, Mr. Mkhize. I'll now call upon Madam Maseti.
Thank you, Chairperson, and thanks to ESCOM for the presentation. I there's a couple of things that were said here that I found them to be, inconsistent with each other. Firstly, it was stated that the proposed market code is supported. That's the first presenter from ESCOM. It is supported. But at the same time, there are statements that say, there's a market design paper that must be in place first before we can have this. Then I get another, statement that says there's a couple of things to be done: due diligence, risk assessment, and all of that. Then there is another one that says, well, NERSA cannot approve this without certain things being fixed. Then there's another slide that talks about, if you do it, maybe you must approve it subject to certain things, or it must be approved, and then there must be a phasing in of certain parts of the market or market code. I'm mentioning all of these things because I was trying to figure out whether the position, the formal position from ESCOM, is to say they are in support of this. It is fine. It meets certain requirements because we're given 80% here. So if it says 80%, and then now there are other things that are said to have certain impact, adverse effect. Can we be clarified on that? What exactly is ESCOM's saying here? You are not in support of this, you are objecting to this completely, and what are your bases? And so that from our side, we can also look at what potential harm that you want to convey to the regulator if the regulator were to approve the market codes. That's the first question, so that we can then get clarity. I would also like to understand the issue of the due diligence, in as much as it has not been sort of discussed at length insofar as the scope of the due diligence. I take it that there will be technical issues such as the grid security that you spoke about, to do some stress test as well, and that there's a number of other things maybe that could happen. So, and you stated that NTCSA did not provide the due diligence that you requested. It is important for us with the matter that is before us, and it is at this stage that we are informed about the scope of the due diligence that you require at NTCSA to deal with, so that we understand whether this due diligence is something that could threaten security of supply or market integrity, consumer interest, and ensuring consumer protection, or even the orderly development of the South African wholesale electricity market. So for us, that's what, at least from a regulatory perspective, we would like to understand. Then, if then there are certain risk, I would like to find out, this is the third question, about whether NTCSA has, you have spoken to them about the risk that you have just identified and touched on in your presentation today, whether you have asked NTCSA to provide a risk mitigation plan that is supported by appropriate technical as well as operational evidence, demonstrating that the risk that you have identified have been addressed prior to the commencement of the market operation. Did you do that? I think for us, it is very important that we do get a perspective of, I'm not going to dwell much on curtailment. That's something else, and countries have dealt with it differently, and all of that. I fully appreciate the concerns that you have raised. But for now, I just want to to deal with the issue of the risk mitigation, whether NTCSA was requested to submit some form of a comprehensive market readiness, number one. Number two, whether NTCSA was requested to submit a risk mitigation plan, given the fact that you highlighted those things before us today. And if so, what was the response? Have they done that? So that also from our side, we can request that NTCSA furnish such documents to the regulator for the regulator to independently verify and satisfy itself in regarding these things that are highlighted. Then I would like to move on quickly to the issue of, I'm not going to dwell in all of the risk areas anyway, financial risk, capacity adequacy, system security. You mentioned the issue of dispatch, issue of transparency. I think surveillance as well is quite important there in terms of the operational monitoring systems and reporting protocols. It's quite important. And the market readiness that you've touched on. Just to get to the NMD here, you just mentioned NMD, but from our side, even if we're to entertain that aspect, as we have the rules around NMD, but it is not this is not a given thing. It is not supposed to be notional cost. That's simply because a municipality defaulted and could not take up the demand that was indicated or nominated, and therefore that municipality automatically must incur penalties. For us, it will be cost reflective because we also understand the burden of the NMD on municipalities when they are imposed by ESCOM, in as much as when there is load shedding, ESCOM could not perform, and then the municipalities also may have indicated how much demand they require. If ESCOM is not able to supply that demand, then what happens if the penalty is from one side? And I'm not saying that let's get to that debate, but I'm also saying that as an independent regulator, we also do give due consideration to some of the balancing or fair balancing of the issues of cost, but we must do it if those costs are prudent, if those costs are cost reflective, if those costs are efficient. So NMD is not a guaranteed income stream for one party, and if it is not shown that the costs are cost reflective and are efficient. That's another point that I just needed to touch on. Very quickly, I will skip the part where you disagree on the issue of dispute resolution and also settlement, credit disputes and all of that. I suppose when NTCSA comes in the end, before we close, NTCSA will pick up on this issue because we are flagging it from our side, and they must give response so that we hear how they respond to that question that you have posed. There's just one more issue that I needed. Oh yeah, the suspension of the balancing. I'm not sure whether this is the balancing capacity or what. What are the reasons for that? Why should and if that is the case, then how that is going to affect the market itself? If then it must be suspended, and for how long? Because it is important from our side as the regulator that we avoid any undue delay in the matter that is before us, of which delay will also affect the operation of SAWEC. So in as much as there are concerns raised by stakeholders, we must understand what is pragmatic, and it must also be justified insofar as, or from the perspective of what impact it will have in the market if this is not done or it is done the way that it is proposed. So when one puts a problem before us, if ESCOM puts certain challenges or concerns, ESCOM must also be in a position to demonstrate the harm associated with the problem that ESCOM has identified. And it will also be appreciated if not only to identify the problem and indicate the impact of that problem, but also the proposed solution to that problem, so that we can all get somewhere and understand that this is not just things that are put before us as obstruction, but this is a constructive stakeholder engagement, and we can see what are the sort of feasible solutions that could work for the market and to mitigate any sort of risk and negative impact. We will appreciate if we can take that kind of approach, because it takes us somewhere, and the regulator will then be able to see what is it that we can do, what is it that can be done next, if then we take into account some of your proposals on your last slide. I would like to leave it here, Chairperson, because we don't have much time, and I wouldn't want to take a lot of time, but I think there's a couple of things that we can talk about. Thanks.
Thank you, Madam Masedi. I'm now going to leave it then to the ESCOM team to respond. You're going to decide who responds to what. Thank you, ESCOM team.
Thank you, Chair, for the opportunity to respond. We'll respond to some of the questions, maybe most of the questions, and the others will provide our responses in writing. So I'll go first. And then, yeah, to reiterate what we're saying ESCOM supports the development of the market, which includes the market code. So I confirm that, I reiterate that. And we're saying, however, there's gaps, and then some of these gaps are material, and they need to be addressed. So that's what we are saying. So this market of ours, the SAWEM, requires us to submit a forecast, a daily forecast. And then if your forecast has a big errors, you incur penalties. So municipalities, I'll give an example, such as in Msunduzi. ESCOM will be participating in the market on their behalf. And then we know that these municipalities, they don't have forecasting capabilities. I can confidently say that the majority of municipalities in South Africa, they don't have day-ahead forecasting capabilities. And the proxy for that can be the NMD. So the NMD was mentioned as a proxy for day-ahead forecasting. So Msunduzi can't do a day-ahead forecasting, and ESCOM is participating on their behalf. And because Msunduzi's data has got a lot of errors, we are going to incur penalties on the market. So the question is, what must we do with those penalties? So how it is dealt with internationally is there's pass-through mechanisms on those penalties. For example, you can develop a tariff that says if Msunduzi is very good at forecasting, then they won't be penalized. Their tariff will be 0 cents per kilowatt hour. But if Msunduzi's forecasting is terrible, then they're going to be penalized at the rate of, example, 1 cent per kilowatt hour. This is done elsewhere. It's done in other markets as well. And we as ESCOM, we have contacted the University of Stellenbosch to crystallize this solution so that we can share it with the market. But as it currently standing, ESCOM is going to incur these penalties, and we don't have any mechanism of sending those penalties to the municipalities who are not forecasting, who are not able to forecast as we speak. So hence what we are asking for is we are asking for pass-through mechanisms. All over the world, there's pass-through mechanisms. The issue with our market is we developed the wholesale side of the market, the wholesale code, the market code, but we never put an emphasis on developing the retail side of the market, the retail code, which comes with pass-through mechanism. So all we are asking for is, Chair, if you approve the market code as it is currently, Eskom might see in excess of 2 billion rand per year penalties on balancing, and there's nothing that we can do about it, Chair. There's nothing at all. So we're asking you to empower us by developing a pass-through mechanism similar to how other countries have done it, so that we can further incentivize the municipalities to participate efficiently in this market through a pass-through mechanism, Chair. That's what we were saying on the penalties, and why we're asking you to suspend that. And yes, NTSA has agreed in the simulation phase to suspend that, Chair. My colleagues will come in and cover the other legal aspect, but one thing that I want to say is on the balancing mechanism. On the curtailment. The curtailment is designed such that the risk is removed from the generator and is passed on to the aunties and the cocos. Not even the mines, not even the smelters, etc. It's passed on to the aunties and the cocos through an ancillary services charge. That's how it is designed in the market code. And our proposal to you, Chair, is if you want to proceed like that, it's fine. But what you need to ask the market code to do is to separately ring-fence the curtailment cost, because currently they are hidden inside the ancillary services. The market code is written such that you will never have a view of how the curtailment costs look like. So we are asking the market code to unbundle that so that you can be empowered and see this number increasing from the current 2 billion rand to the future 10 billion rand. But what we are also saying, sir, is we are confused on this design. We've never seen it anywhere on the planet. Everywhere else on the planet is treated differently. So the other stuff that are technical, we'll put it on the letters, Chair. At this point, allow my colleagues to come in. Thank you.
Thanks. Chair, I will deal with the legal questions. First from Mr. McKees on the issue of information requirements and changing the law. We do not recommend changing the law. What our concern is the way the market code is drafted. When you say what the MSU deems relevant, that's a wide category. We need clarity on what it is. If it's said in terms of PIA or POPIA, we're fine with that. We know what we have to provide you. But when it's open-ended as into what you deem relevant, that means we could be providing you confidential information, and we will not be doing that. And that is our concern. Then I want to touch on the NERSA codes versus market code, and this is a big issue for us. Currently, if you look at the NERSA codes, the way it's done is, and in section 35 provides the guidance on that, it says, NERSA, you will consult all interested and affected parties and licensees before you develop a code. And NERSA chairs that meeting, and they do a very good job. Everybody gets to have a say in that. If you look at the governance of the market code, it doesn't follow that process. It has limited outside influence. So if we are sitting with a group of people in that committee of 8, and none of them represent distribution, for example, you could get something approved that works against distribution. That is a big concern for us. And that's why we're drawing that very clear distinction that if anything, and if you read section 35, it talks about the security and operation and maintenance of the transmission and distribution power systems. Anything in that category must go to the NERSA codes, and it must be dealt with under the ambit of NERSA, because we all get to have a say in it. Touching on this point, Chair, I want to add, and I'm going to get to the legal due diligence. When NERSA addresses a code, they don't just say, well, the Chair doesn't just say, we like this and we don't like this. They'll give you a proper technical reason as to why something was accepted. When we raise queries on the market code, that is not what happened. We never got to debate it. We never got to discuss it. It was a few people that decided what was acceptable. Now, if I want to get into the legal due diligence, and this is a big concern for us, at every workshop, Eskom raised legal concerns. We were told, we're not going to go into your concerns now. There's going to be a legal due diligence, and it will be shared with you. So if you look at NERSA, when they make a decision and they publish an RFD, you'll see sometimes they put a table in. And in that table, they'll put the issue that was raised and the nurse's view of it. We don't know how this market code was done. We don't know how our issues were addressed. And hence we've been asking for the legal due diligence. But the due diligence goes beyond that. If you are establishing a market that's going to affect the entire industry, there should be a legal due diligence, a technical due diligence, and a financial due diligence. How will the money flow? How will the risks be addressed? What is the impact to the industry? We haven't seen those. And we've repeatedly asked for the legal one and we haven't got it. I'm not sure if NTCSA has done one on the technical capabilities and on the financial flows, because all of that will have an impact on the industry. And to make such a big decision as to roll out a market, we should have all this information available to us before we do it. Chair, I'll just leave it at that for now, but if there's anything we've missed, we will send them to you in writing. Thank you.
Thank you, Chair. Thank you, Chair.
Thank you. So thank you very much, Team ESCOM. We are now going to go on to the next presenter, Mr. Mick from the South Durban Community Alliance. So, Mr. Mick, can you please switch on your camera and alert me once it's switched on so that I can find you here on my screen. Mr. Mick from South Durban Community, please switch on your camera and alert me once you've done so, because you need to take an oath. I'm not sure whether Mr. Mick has joined us, but he is one of the presenters in terms of our agenda. Maybe he will get a response later on, but for now, I'm therefore going to go on to the next presentation, number 6. But if Mr. Mick is available later on, maybe through you, Secretariat, and maybe they will help you as well to alert me that is now available. So I'm now going to go to number 6 in terms of presentations from Independent Energy Pool. I see here it's Mr. Defender, Madam Delima, and Mr. Langridge. Can I ask them to switch on their cameras before they take the oath, and also alert me if they are ready to do that? Independent Energy Pool. Independent Energy Pool. Mr. Van der Vender, Madam Delima, Mr. Langridge, can you switch on your cameras and also let me know once you've done that so that you can take the oath? All right, I don't hear any response. So for now, again, I'm going to rely on the Secretariat once the Independent Energy Pool team is available. Then we'll come back to them because they are on the agenda. But in the interest of time, we'll go then to number 7 in terms of the agenda, in terms of the presentation from the Smartsville Traditional Fishing Community, Mr. Deval. Can I ask Mr. Deval to switch on his camera and also alert me that his camera is switched on? Secretariat, are you there? Can I check with the Secretariat?
Yes, Chair, I'm here. Chair, can you please move on to the other presenters because we had received interest. However, they had not provided us with presentations. So I'll try to get hold of them on the side
Yeah.
if they're still interested to make
right.
presentations.
All right, but for me, for now, let me follow the agenda that was given to me so that I do not get confused. So at the moment, sounds like Mr. Deval from Smartsville, Traditional Fishing Community, is not yet available. Fine, then I'm going to go to number 8, which is Energy Intensive Users Group, Mr. Mondi. Mr. Mondi, can you please switch on your camera and just alert me once you switch it on so that I can also find you on my screen?
Chair, yes, I'm connecting my camera. Can I just check if you can hear me?
I can hear you, Mr. Mondi. Thank you very much.
Thank you, Chair.
Okay, Mr. Mondi, can you please then raise your right hand and affirm the following? Do you solemnly
Chair, maybe before we do that, can I just ask my co-presenter? Yes, Chair, our chairperson of EIUJ, Murendeni, that will be sworn together, Chair.
All right, let's do that. So it's 2 of you. If you can therefore, please, together, the 2 of you.
Please do them one by one, Chair, so that everyone takes his oath, please, and be conscious of of what is doing. One by one, Chair.
All right, we can do that. Let's do it one by one. Starting with you, Mr. Mondi. If you can raise your right hand and affirm the following, do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
I do, Chair. Thank you.
So for the record, please state your name, organization, and designation.
My name is Fanele Mondi. I'm the CEO of Energy Intensive Users Group of Southern Africa, EIUG for short. Thank you, Chair.
Thank you, Mr. Mondi. And then we also have the chairman of EIUG. Mr. Chairman, please raise your hand and affirm the following. Do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
I do, Chair.
For the record, please state your name, organization, and designation.
Murendeni Machinetsimbi, chairperson of the EIUG.
Thank you. Please remember to forward your presentation to public hearings at nesa.org.za so you can proceed with your 15-minute presentation. Thank you. Over to you.
Thank you, Chair. Can I confirm if you can see my presentation?
Yes, Mr. Mondi, thank you.
Thank you, Chair. Thanks for the opportunity, Chair. We will quickly go through some of these slides. We have quite a few slides in here. Maybe just to set the context is that we responded to the consultation paper, but we felt that there were certain issues which were not coming up based on the questions which were raised on the consultation paper, and we're bringing those here. For instance, the questions which Mr. Mkhize was asking about the role of the NESA in terms of some of the governing structures. We share some of those views, and we have indicated as such in our submission that we believe that for independence purposes, probably NESA should have a much prominent role than currently defined on the terms or on the code. So we are not going to go in there. That information is available there, Chair. But going straight to our presentation, one is that we must probably first thank NTCSA for the work they did, the consultation process they went through. It was quite intensive, Chair. It was also a lot of work on their side, as well as the stakeholders. So we do appreciate it. However, having said that, we obviously still have some areas where we think that there are some gaps. So our purpose of this presentation is to say the market code as revised marks certainly an important step towards a competitive wholesale electricity market. However, in as much as EIUG, we support the reform itself and the associated rules, we remain cautious about some of the issues which are yet not resolved, and we believe that they may then weaken the implementation. In terms of this presentation, we're trying to cover some of those aspects, Chair. In terms of the market code, we believe that it is a necessary document. It certainly promotes competition. We believe that it assists us in terms of price discovery. It also gives us an opportunity to integrate renewable energy into the grid. And the governance proposals, we think they are fairly good in terms of saying we need a governance framework. And then in terms of the regional trade, we are also of the view that it is good that it opens those pathways for participation in the bigger South African power pool. In terms of the governance and roles, we just want to emphasize some few points. One is that the NESA role should be aligned strictly with the ERA. We believe that the municipal BRP obligations require some legal clarity, given the constitution and what is allocated to them, as well as the Municipal Finance Management Act, as well as I think the point which was raised by the regulators much earlier in this hearing around the debt position, where we say that the municipalities, by and large, we know that they are financially constrained and carrying, as we speak, quite significant Eskom debt. The hierarchy between market code, the grid code, distribution codes and ERA, we believe that it is not very clear, Chair. It may need further clarity in terms of how these codes relate to those documents specifically. In terms of the recommendation, we believe that the governance, in as much as we acknowledge there is a lot of work that has been done, it can be further strengthened. And we can also ensure that the roles remain legally enforceable as well as institutionally realistic, Chair. And then the market readiness, I think there are people who touched on this. I'm not going to go into any details. We believe that the issues around the SMP are fairly broadly defined, but we believe that there may still be some work that needs to be done further regarding the governance, the market participant readiness, the capacity remuneration mechanism design, the vesting contract, skills development, as well as IPP insofar as it relates in our case with our bilateral PPAs with them, may need to be further looked at, Chair. We also are of the view that the role of NESA is significantly changing. So there may well be matters of NESA capacitation which may be required, as well as the rules in terms of enforcement, in terms of the municipal participation. I think Eskom has raised a few concerns in that regard as well. The code hierarchy, I already spoke to that, and we believe that the cost allocation remains critical. I think Eskom also touched on that. So the question is, are we really ready in that regard? Overall, our view is that readiness seems uneven, though technical design is advancing fast. The institutional and legal and participant readiness, we believe that it may not be there. These matters, Chair, I must concede they are not necessarily dealing with the code, but they delay in part with SAWEM, but we think the two are interlinked, Chair. There are also concerns on our side around pricing and tariff risk. I think the issue of socialization of constraint costs may weaken the localization signal or locational signals and may distort siting decisions for generation and demand response. The caps, we believe, though they are necessary together with incomplete long-term investment mechanism, could undermine new generation investment, in which case then we could find ourselves remaining with constrained energy supplies into the future. The legacy charge recovery must avoid placing disproportionate costs on energy-intensive consumers and stifling competition. I acknowledge that it seems Eskom view this matter differently, but I think it is the same issue to say there is a bit of transparency and probably alignment that is required in terms of cost recovery. And then transparent settlement, balancing, reconciliation rules, we believe are essential to protect industrial competitiveness. Sorry. And then some of the risks we have identified for our constituency is that cost recovery and tariff rules are still under, or we acknowledge that cost recovery and tariff rules are still under development, and the introduction of multiple overlapping pricing frameworks may cause a bit of a risk, considering that we are, as the others people would say, we are building as we go along, so we are concerned about that. But we are fully aware that there is some work happening behind the scenes. Inadequate default risk measures, collateral arrangements and suspension rules could create a systemic market risk. We believe that this is not fully defined. It will pose risks, especially if we think that we can just simply socialize those costs to everyone else, so we think that we need to tighten on that. Municipal financial instability could unintendedly transfer risk across the market if BRP obligations are not properly designed. Limited transparency on balancing, constraints, and settlement could weaken consumer confidence and competitiveness. In terms of what we consider to be the priorities, one is to align with ERA. We want to advocate that the NESA's role with ERA must be aligned, as well as clarity regarding the market operator, CPA, and governance functions need further clarification. In terms of the legal hierarchy, define the legal hierarchy between the market code, grid codes, distribution code, and primary legislation. In terms of the CFDs and CRMs, we believe that there is a need to introduce vesting CFDs, CRM, and transparent treatment of constraints. Costs, whether these are done as part of the market code or as part of the market design, I think those are the issues we may want to deliberate on. We believe that we need to protect the bilateral PPAs in the sense that we believe that the bilateral PPA, that is the existing one, needs protection through some transitional provisions. The concern here, Chair, is that the bilateral, I think, is something which Eskom also touched on in terms of non-market participants versus market participants, insofar as the balancing responsibilities apply, where you may have concluded a particular contract before the market or SAWEM, and now all of a sudden you have new costs arising out of that contract. It will definitely create problems, and hence we say that we need to caution there with a little bit of more care to say how do we make sure that we do not destroy what we have already built at this point. Strengthen market surveillance settlement, transparency, collateral requirements, and default risk need protection. And then the market code is attempting to resolve issues that should have been addressed with market design paper stage, particularly institutional capability and regulatory readiness. In this regard, Chair, we are fully aligned with what ESCOM was saying about the need for a market design as a precursor to the market code. We think that we are doing things the opposite way. In as much as we understand, I think the point which was raised by the regulator that there is also an agency, but it doesn't take away the fact that we could have designed this differently. Recommended.
Sorry, Mr. Monde, you've got 5 minutes between the two of you. 5 minutes left. Thank you.
I will do the presentation, Chair, and then Morendeni will assist with the questions and answers, Chair.
All right, we've got 5 minutes left. Thank you.
Thank you. And then in terms of the recommended implementation conditions, we still believe that a conceptual wholesale market design should be finalized before further work is undertaken. And then a market design paper, we believe that it should typically sit upstream of the market code and go broader than the rules. It would frame policy direction, design choices, and trade-offs before locking them into regulatory instruments. Institutional mandates, market governance, and dispute resolution arrangements should be legally tested and operationally resourced. Participant readiness assessment should be completed for municipalities, BRPs, traders, IPPs, and our constituency, which is the large power consumers. Pricing, settlement, balancing, and constraint cost methodologies should be published and tested before implementation. We believe that there is a need to develop some kind of a wholesale market, a sandpit or sandbox for participants to practice prior to the commencement of the market, and that phase in pricing data beforehand to enable adequate modeling and preparation before we go fully into the market. We also, as we understand that ESCOM is already piloting some of this work, that maybe that some of that information could be shared with the stakeholders so that they can start understanding issues around the price point, as well as looking at the energy trading, traded pricing, that is a variable cost excluding all other costs, so that we could have a better understanding and readiness. In conclusion, Chair, we believe the market code 2026 is a necessary and positive reform, but it may not yet be implementation ready across all dimensions. And we are saying the most material risk related to legal certainty, institutional capacity, municipal participation, bilateral PPAs treatment, cost allocation, as well as transition design. EIUG supports market reform while encouraging practical safeguards to protect competitiveness, investment confidence, and system reliability. That's it, Chair, on our side. Thank you for the opportunity.
Thank you very much, Mr. Monde. We'll now open it up to the members. If they've got any questions, over to you, members. Let's start with Mr. Mkhize.
Thank you very much. I think with regards to what IEUG and ESCOM, as well as the others have presented, it just that there's a lot of work that needs to be done and to put this together. I'd just like to thank EIUG for the presentation and request that maybe in terms of their contribution is to maybe going back to the previous slide. So I think it's slide 12, starting from slide 10 actually to 12, where there are these key risks that you've identified, and then you're saying these are the things that need to be done in order of priority, so to say. Maybe it will help for you to provide some kind of a roadmap together with the team in terms of what needs to be done, because we don't want any party to be seen to be delaying the process, but that the process is done in a manner that is actually assisting in terms of a final product that will help and have the best SAWEM we can afford to have in the country. And that also then requires just maybe to go one level down to kind of map out maybe a program plan, so to say, so that if there are certain parts that there's some kind of agreement on, maybe they can be noted as such and there's forward movement. I would request that maybe you provide that kind of a written submission, and with due respect of in taking into consideration of what is emanated from other role players, and in coming up with your arguments, please do take into consideration counter arguments and the mitigation of whatever will remain out of that. Yes, because for me to really ask you pinpointed question on this, I don't think it will help as much as you providing that kind of a detailed outline, and that we own up in terms of whatever delays that could emanate, which are not necessarily coming from one party. And I heard earlier on there was this issue of saying certain things can be taken on review. I think on the same time from our side, it's not necessary to do things with fear of being taken on review, but it's to be able to have a product that is going to be that is going to serve the electricity industry in Mzansi. Yeah, let me leave it at that, Chairperson. Thank you very much for the opportunity.
Thank you, Mr. Mkize. I will now call upon Madam Maseti.
Thank you, Chairperson, and thank you to Mr. Mondi for the presentation. I'm quite concerned about this issue coming up again, and it is a crucial issue, which is the market design that is not in place, or there is no market design paper in place, and I'm seeing it in EIUG's presentation as well. Now, this is brought to the regulator to indicate to the regulator that there is a policy gap here, as something that is crucial that should come before we approve the market code. And then this, now it was stated by ESCOM, now by EIUG. This now worries me around the risk of a policy and market code mismatch, where, for instance, the code may have proposed certain things, and then we approve, and then those things they kind of hardwire some policy choices that the DEE has not formally adopted or approved. That worries me, and I would like Mr. Mondi to come to that, and maybe so that we can get some perspective there as to how do we deal with this kind of a situation, particularly if this is something that the department may come up with something that is completely, or some aspects that are completely different from what the code has proposed, when in fact the code must take cue from the market design. And then I just want to check if, because ESCOM did say that it supports, and therefore if there's approval, there must be phase in. So I wanted to find out if from your side, you are also suggesting that NERSA may approve this proposed code, to the extent that some of the concerns raised or that the code maybe is aligned with an approved national market design framework, which is not in place. I'm just saying because ESCOM also made certain suggestions on sort of conditional approval. I'm just asking from your side, since you raised the same issue, are you supporting approval that is aligned with the market design framework, and also maybe subject to, because there are sort of other things that were raised, subject to NTCSA also submitting the risk assessment and risk mitigation plans, which we spoke about in the presentation during ESCOM's submissions that were made today, especially on issues of capacity adequacy, financial settlements or credit settlements, system security, dispatch, transparency, and market conduct, including market surveillance and competition aspects. So that is the first thing that I just want to understand, because for me now, this issue of the market code is quite important. And it may well be important in terms of the model that government has in mind, the market model that government has in mind, especially because we talk about municipalities that don't have certain capacity to do certain things like the forecasting, or municipalities that are financially not sustainable, and also even the role of the CPA, Central Purchasing Agency, and all of these other things about the vesting contracts and stuff like that. So that for me becomes the market design becomes critical in outlining those things, so that the code gets hardwired to what that policy proposal and approach is for the market in South Africa. You just want to check the other point that you made. The other point that I wanted to find out is the issue of a SAWEM market code being different from a market code or market rules, market conduct rules that NERSA must develop or must have or approve. Are you also in agreement that there can be those two different regulatory tools, but one does not have the legal powers as we have it in the Act, the SAWEM one, but it will be kind of an industry code of conduct, which is a market code. And it's something that happens in industries in any event, to have an industry code of conduct that the market operator would monitor and ensure that the market participants, they live by those codes. So that's one thing, and becomes voluntary because it will not have some sort of legal enforcement compared to the legal powers that the regulator would have in terms of the rules and enforcing market, enforcing the rules insofar as the contraventions occur in terms of the market conduct. So I was just amplifying the differences between these two. Are you also in agreement that there should be a situation like that, that such market codes and market conduct rules can coexist? Those are the questions that I wanted to get clarity on. Thank you very much.
Thank you, Madam Maseti. So can I now leave it then to the presenters to respond?
Thank you. Do you want to go first, finally?
No, you can proceed, Chair.
Thank you. Thank you, Mr. Mkize, as well as Ms. Namfunda, for those valuable comments. Maybe if I may just start to address an umbrella response in terms of our concern as the EIUG. I think our biggest concern here is about how do we ensure that we address failure to launch. As much as we're in support of the market, is how do we ensure that we have got measures in place that we make this a success, taking into account or understanding that if we do fail to try and revive it might take a while. So we are coming from that point of view of saying, while we agree that this is a great development of the market code, but can we try and put in measures to ensure that this market, SAWEM in particular, it's a success, especially after all the efforts which has been put up to this point. And another point which was raised when what we deliberated on as we're preparing this presentation was around, if I may use the analogy of a conductor, that what seems to be obvious to us is the main conductor who basically bringing all these parcels together to complete this picture. Our understanding is that that should be DEE, and obviously part of the question which came up with how will NESA deal with this response or presentation, the outcome of this presentation. Is it NESA taking this to DE to say this is their concern, or will NESA just make a decision on their own? So again, just trying to respond to some of the concern which are raised by Mr. Mkhize of saying maybe we should come with counter arguments, mitigation plan, or a MAP program plan. Our view is that DE should be having that master plan, ensuring that all these puzzles are filled together. But we are happy to support to ensure that everything fits together and work and we can respond on time. There was also another comment around concern on the market design and if there's a mismatch between a market code and SAWEM. Our view on that is there should be, I think, a consultation on that to allow input to ensure that even if there's a difference, we can differ in terms of who has power to take a decision, but the principle themselves, they should be aligned between a market code as well as the what's that point which was raised here? The market code as well as the SAWEM. Alignment should be at least be achieved between the two, even though maybe another party might not be able to take certain decisions, but we shouldn't be differing on that. Those are some of the points which I've highlighted here, but I'm happy to expand if need be. But again, just to reiterate, to say, really our concern where it's coming from is not to say that we are not ready, but to say how do we ensure that when we do launch, we launch for success and make this market work. Thank you.
Chair, if I may just add to what Morendeno was saying. I think that's our starting point, like he's saying, it's where we're saying that a risk of failure is probably the worst circumstances for us than a risk of delay. So we are of the view that this matter is urgent. We should have reformed our market long time ago. We are certainly falling behind, but we are saying that we need to be cautious because we cannot afford to fail. I think that's a key message in terms of that. In terms of the proposal by Mr. Mkhize about us submitting some kind of proposals, we will reflect on that because it's like we're saying is that this thing is new for all of us, and hence we were saying that we certainly appreciate the work which has been done by NTCSA, putting all this thought together. It's not as if we say that we've got all the solutions ourselves, but it's to identify things where we think we are concerned about. And to this effect, we have made the official submission, but we also submitted the original submission we prepared for NTCSA consultation so that you can have a broader view of the issues which we were raising. Some of them, yes, have since been addressed, but some of them were not addressed as yet. So we have already made quite a substantive submission in that regard. Regarding the issues, Ms. Masetti, you were raising around the risk of market design and market code gaps. I like the way you summarize it because it's at the core of what we're trying to say. Is to say that we could find ourselves locking ourselves into a position where we're difficult to get out of, by this arrangement we've had. I don't know what is the solution, but just thinking aloud, one of the things, in my view, we could do, one is to identify the gaps where we say that, okay, there are these gaps which still needs to be concluded, but we can still proceed as a transitional, code instead of a full market code. We say that these are the gaps. And this is a transitionary code, and then it will be further amended once, for instance, there is a clear market design. Once members have had an opportunity to play, for instance, within the sandpit as we're proposing, because in that case, then there's further learning which we can bring out of that to build up on this code. So I think at this point, that's what I could think of at the moment. And regarding the issues of the market rules, as well as the regulated rules and versus non-regulated industry rules, we think we will need to tread very carefully. Our view is that we should stick as much as possible with the ERA, but certainly there may well be a room for that as long as it doesn't contradict, the legislation. I think that's what is going to be important. My last comment, Chair, I think Mr. Mkhize didn't imply that we talked about taking the matters for review. I think he was talking generally, but I think for the record, I must put it here that we have no intentions of taking anything to any review as EIUG at this point. Thank you, Chair.
Okay, thank you very much from the EIUG team. What we'll do now, we're going to then move on to the next presenter, which is now item number 9, Madam Pullen. So, Madam Pullen, may I ask you to switch on your microphone and also just alert us when you've switched on your microphone because we'll need to take an oath.
Thank you.
Thank you. Can I then ask you, Madam Pullen, to raise your right hand and affirm the following? Do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
I solemnly declare, Chair. Thank you.
For the record, please state your name, organization, and designation.
My name is Rainet Melissa Pullen, and I'm a small-scale fisherwoman from the Eastern Cape. And I am the chairperson of Mukasako Fishery Cooperative.
Thank you, ma'am. Please remember to forward your presentation to public hearings at nesa.org.za. You may proceed with your 15-minute presentation.
Thank you, Chair. Chair, I just want to bring to your attention, I don't have a PowerPoint presentation here today. I would just like to present my comments and just a few questions.
That is all in order. Thank you, ma'am.
Thank you, Chair. Chair, today I present these comments as a small-scale fisherwoman, community activist, and an advocate for social and environmental justice. While I acknowledge the need to reform South Africa's electricity sector and improve energy security, I am concerned that the proposed wholesale electricity market may place an additional burden on poor and vulnerable communities if affordability and equity are not prioritized. Many coastal and fishing communities already face high levels of unemployment, poverty, food insecurity, and the increasing impacts of climate change. Electricity is not a luxury for our communities. It is essential for household well-being, food preservation, small businesses, and livelihoods. Any increase in electricity cost will have direct consequences for families who are already struggling to meet their basic needs. I therefore call on NERSA and policymakers to ensure that affordability remains a central principle of the new market design. Electricity should not become unaffordable because of cost-reflective pricing mechanisms. Free basic electricity and social protection measures must be strengthened and protected. Vulnerable households should not bear the cost of market restructuring. The impact on small-scale fishing communities, rural communities, and low-income households must be specifically assessed. These communities are often overlooked in national energy planning processes. Community participation and energy justice must be embedded in the market rules. Communities affected by energy decisions should have meaningful opportunities to participate in decision-making. The energy transition must support social and environmental justice. Investments should prioritize renewable energy solutions that create local benefits, protect the environment, and contribute to community resilience. The market should not deepen existing inequalities. Safeguards must be introduced to prevent wealthier consumers from benefiting, while poorer households carry a disproportionate share of system costs. South Africa's energy future must be both sustainable and just. The success of these reforms should not be measured only by market efficiency, but also by whether they improve the lives of ordinary people and ensure access to affordable electricity for all. I've also got a short statement that I want to make. Energy is a public good and a basic human need. Market reforms must not come at the expense of poor households, fishing communities, women-headed households, and future generations. A just energy transition must place people, livelihoods, and environmental sustainability at its center. Chair, I just got a few questions that I would like to direct to NERSA. How will NERSA ensure that the transition?
Sorry, excuse me, ma'am.
Yes, Chair.
Just one issue here. That as we said at the beginning of the meeting, in terms of the rules,
Yes,
only
Chair.
members of the panel may ask questions to the presenters.
Okay.
So I cannot allow you to ask any questions to the presenters. Thank you.
All in order, Chair. Thank you.
This says to NERSA. It's asking a question to NERSA. You can let her post a question even if you're not gonna answer it. She's saying she wants to pose a question to NERSA, not to the presenters, Chair. Thank you.
All right, you can then ask that question.
Thank you, Chair. So this is in regards to affordability, Chair. The question is directed to NERSA. How will NERSA ensure that the transition to a competitive wholesale electricity market does not result in higher electricity prices for poor households and vulnerable communities who are already struggling to afford basic services? Then my next question is, women often carry the greatest burden when household costs increase. How have gender impacts been considered in developing the wholesale electricity market and its pricing methodologies? Then my last question to NERSA, Chair. How does this new electricity market support South Africa's climate commitments while ensuring that the cost of the energy transition are not unfairly shifted onto poor communities? Thank you, Chair.
Thank you, Madam Pulen. So firstly, we note your questions. You say addressing them to NERSA. So I don't think we'll be able to answer the questions here today, your questions, because it's going to need then the NERSA people, the department responsible to come up with the answers. As to exactly how your answer is gonna be given and when, I think we will deal with that offline. So for now, but however, I also see as well there is a hand up from Miriam Maseti. Miriam Maseti, your hand is up.
Thank you, Chairperson, and thanks to the presenter. I just wanted to acknowledge the issues, even if you have framed them as questions, but it is issues of affordability, issues of climate change, issues pertaining to women, the impact of the rules that we're making and some of the initiatives. So what I can say is that we will take those things into consideration as NERSA in our decision making. That's all that we can state at this point in time. So those will be part and parcel of the analysis, and then NERSA will take those into account during the decision that we are going to take. Thank you very much, Chair.
Thank you, Madam Maseti. I also see Mr. Mkiza as well.
No, from my side, Chairperson, as a platform primarily for the panel to ask questions, to solicit further inputs to enrich the final decision, I can only note what has come through, which are matters that were also highlighted before in terms of all the stakeholders, to ensure that they take due cognizance of these matters of affordability for all the different classes of customers. Thank you.
Thank you. So may I just then double check with the members if they've got any further questions for Madam Pulen? I do not see any hands. So thank you very much, Madam Pulen. We'll now go on to number 10 in terms of the presenters. Mr. Howie from G7 Renewables Energies. Can I, Mr. Kai Howie? Yes, good afternoon. Thank you very much. So can I therefore ask you, Mr. Howie, to raise your right hand and affirm the following? Do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
Thank you, Mr. Chair. My name is Kai Howie. I'm from G7 Renewable Energies, and my position is General Counsel. Mr. Chair, with your permission, I'm going to cut my video and I'm going to attempt to share our PowerPoint presentation.
So sorry, before you
Is it-
proceed, so thank you for that. Then can I also ask you to remember to forward your presentation to the public hearings at nesa.org.za. So you can now proceed. We've got your 15 minutes. Thank you.
Thank you, Mr. Chair. I'll proceed as briskly as possible, noting the time of the hearing and the fairness of some of the previous submissions. So, in terms of this presentation, I'm going to briefly introduce who G7 is, and then I'm going to talk through some overarching themes, both our perspective on the market code as well as touching on some themes that may have been raised, that we've seen from other stakeholders, and then go into a few of the minutiae of the market code, which we believe deserves nurses' focused attention due to the importance of the issues under discussion. So in brief, just by way of introduction, G7 Renewable Energies, we are a renewable energy developer. We've developed projects in both the regulated programs as well as in the bilateral market. We focus on development across all renewables technologies, normally at utility scale, and we're active across the full project lifecycle. So in speaking to the various aspects that I will be addressing today, I'm talking from both looking ahead at participating within SAWEM and what it is required to make it a success, but also simultaneously having a look at some of our projects, particularly those with bilateral PPAs and some of the considerations that we have in the back of our mind as to how to ensure that those projects are stable, how we can appropriately plan properly for the introduction of SAWEM to minimize the disruption that is caused and the costs of that on both ourselves and potentially other project counterparties. So to take an overall perspective of the market code and this process that the regulator has been running. Firstly, from our perspective, we are overall in full support of the market code as it has been drafted. A number of the members of our team have been attending the SAWEM schools that have been run by the NTCSA. We've really interrogated the logic of a lot of the design of the day-ahead market, the intraday market, the rules for participation, the governance mechanisms, and so on and so forth. And we've taken the view that these have been prepared with due consideration both to how it is done in other foreign markets, but also looking at South Africa and the needs of the South African specific market dynamics. So in terms of just taking a step back and looking at the process for nurses that's considering today, and I think there's been some conversation where the questions have been raised about whether there needs to be a policy in place that sets the overall roadmap for market deregulation before the regulator can consider it. From our perspective, from a pure, strictly legal point of view, there is no obstacle to the regulator approving the market code as it stands. There's nothing in ERA, which is really the governing document that governs nurses' activities and considering the market code and approving it, that would be breached if NERSA then proceeds with approving it. Obviously, policy roadmap from DOEE is always welcome. It would be fantastic if such is released to the public. But to the extent that one is not currently available, we do not see that as an obstacle to NASA looking at the market code, considering its provisions, considering all the comments and inputs from the various stakeholders, as well as obviously NERSA's mandate, and then approving a market code in line with the ERA Amendment Act. So to come back to our overall perspective, what we are really looking for from this process is to ensure, one, where the process to having the market code being adopted and operated is clear. There's sufficient time for market participants or prospective market participants, or those who will be impacted by the market, for example, the being balancing responsible parties, to have enough time for them to prepare. And then also to ensure that SARWIM itself is both sustainable and sufficiently liquid, which obviously draws us into sort of a wider policy nest, looking at, for example, the vesting contracts and unbundling of a wholesale tariff. But that we will obviously address through those relevant consultation papers. Other than suffice to say that for the purposes of this presentation, we note that it is incredibly important that all market participants, whether sort of, the legacy monopoly or whether potential new entrants and disruptors, are all generally playing on the level playing field, and that you're not having parties having to compete on an uneven basis, except where it is particularly justifiable to do so. So moving ahead and focusing on the balance responsible parties that are not market participants, if we have a look at the process that will have to happen, generally once the market code has been adopted, there is going to have to be a consideration, obviously, of what does this final code look like. Are there any changes to operations of the various sub-elements in the market? For example, the composition of the balancing mechanism. How do the declarations interact with, say, for example, provisions in the wheeling code? And then with that, discussions will have to happen within project companies, with senior lenders, with the off-takers, through change in law provisions, and this process to allow for stability for non-market participant BRPs to decide on the way forward, either to go into the market or to stay out of that, but look at the operational philosophies and adopt whatever mitigation measures are required to reduce the exposure to the balancing mechanism. That takes a significant amount of time to get in place. I'd love to say that the market will be able to adjust, very easily and effectively, but there will have to be a grace period through which allows parties to have go through the appropriate governance processes, have the appropriate commercial discussions on risk allocation, as well as mitigate and investigate the sufficient mitigation measures to ensure that the adoption of a market code does not cause disruption to investments that total in a great many billion. Secondly, one point that has particular impact on the non-market participants, basically the current bilateral PPAs, is the question regarding the crediting of off-takers. It's been mentioned in some of these SARWIM schools that effectively the day-ahead declarations made by the non-market participants will be used to credit the off-takers under those bilateral arrangements. We've not yet seen it being clarified from the market code if that is indeed the case to be done, and we certainly are not opposed to it. We would appreciate it if NERSA could adopt the relevant processes to ensure that is clarified. And if that is indeed not the intention and proceeds as it always has done, i.e. what the actual crediting functions through a function of the metering as actually recorded, then we would appreciate that also being clarified. But then the question would happen, to the extent that the balancing obligation occurs, who is effectively credited with that balancing energy, and that would be a question that has to be resolved. The second issue really is about the pricing of ancillary services. So there's a couple of very technical details about the formulation of some of the formula regarding that, and really what we are trying to ensure here, and perhaps at this stage, it's perhaps apposite for me to point out, we have provided written submissions to the various questions that have been asked, where we're going to detail on some of these issues. But effectively from our position is that we need to ensure that ancillary services are properly designed, that bidders are incentivized to provide ancillary services as opposed to purely making themselves only available for their hit market, particularly where they have capabilities and can provide that perhaps more competitively than what might currently be envisaged in the vesting regime, the vesting contract regime. And obviously, from our perspective, it would be incredibly valuable if the ancillary services system can be liquid and competitively priced to lower the overall costs of the electricity system. I'm not going to go into the technical details. This presentation will, of course, be provided to the members, and we look forward to NERSA giving adequate consideration to this point. Then moving ahead to the intraday market intervals, currently the market code states that there's going to be various gate closures following 6-hour intervals. Now, the problem that a lot of renewable energy developers have, and this is very particular for wind, for example, can also apply to solar, where there could be more cloud cover or less cloud cover than what had been anticipated. And what we have seen from our technical and forecasting modeling is that the closer you get to your dispatch period, your accuracy of your models improves on an exponential basis. So in order to limit the exposure of various renewable projects to balancing charges, we are of the view that where it is technically possible to move these gate closures to being a lot closer to that dispatch period, that we would encourage the market code to allow for that. Because effectively, through doing that, you allow parties to adjust their positions that they may have made a day before with confidence, and this allows for more orderly adjustments that will be beneficial to all parties. Finally, the final point we want to raise is that, SAWEM, I think some of our colleagues from other parts of the industry have mentioned this. SAWEM is something new. It is, and looking at us as potential investors, but also with our discussions with our lenders, it's clear that a lot of information transparency is needed of SAWEM to understand the dynamics of the market, what is driving prices, and what does the outlook look like. And this isn't, and just for the public to have, what the price levels are without understanding what is behind that, doesn't really allow prospective investors and lenders to take a constructive view about what is shaping the market dynamics. So we would encourage NERSA to look at the market code, look at what is not being put out in the public domain or the domain of market participants, and we would encourage NERSA to publicly release as much information as possible, save for that information which is strictly confidential. So in other words, what we are advocating for is, say, for example, release the stack of who forms part of your unconstrained schedule, but anonymize the names so that one does not have access to information because, frankly, there's no justifiable use of that. And then we believe that with that, combined with adequate protections for the market surveillance unit, that this can be sufficient to prevent any collusive behavior or abusive behavior, but it would allow parties and prospective investors who are looking at SAWEM to be able to take a forward-looking view about what is driving it and whether making investments meets the relevant investment cases and risk profiles or not, which should also allow parties to lower their risk premiums because of the fact that they have more access to information. I'm going to stop my presentation there, and I'm happy to take any questions, Mr. Chairperson.
No, thank you very much, sir. And then I'm now going to ask the members by show of hands if they've got any questions. Thank you, members. And I'm going to ask the members, there's a problem with my connection, so I'm now using the cell phone while I'm sorting out. So members, you can just come in if you've got any questions while I sort out my laptop.
Thank you very much, Chairperson, and thank you, Mr. Howie, for the presentation. I just want to pick up on that issue of the issue that you referred to regarding ancillary services. whether you have a particular or specific concern with regards to what has been proposed so far by the market operator or NTCSA. As you've stated in your presentation, that we need to make sure that the ancillary service market is properly designed, so I just want to understand, with regards to ancillary services, what is your specific concern there? And then also linked to that, if you can take down the questions, if you can write them down. I would also like to understand whether you want NERSA to maybe request NTCSA to demonstrate that the ancillary services designs would promote competition rather than favoring certain incumbent providers, and all of the other things, such as ensuring or allowing participation by IPPs and the other people or other stakeholders, and deal with demand response aggregators and all of that. So there are obviously a number of things there that we need to make sure in terms of avoiding or dealing with entry barriers and stuff like that. So, and you touched on another one, which is liquidity, which is quite important. I'm mentioning this because I would like to understand whether you have picked up any concern with regards to what is now proposed, so that NERSA then can be able, during its assessment, touch on these things that I spoke about, on entry barriers, competition, and participation, and all of those. That's the first thing. The second thing that you think you also touched on, you'd also touched on the fact that the issue of the market design is the preserve of the department, and therefore NERSA can do what it has to do with in terms of considering the market code is not prevented. But the only thing that I mentioned earlier on relates to sort of the policy sort of mismatch with the code, such as the things that will be in the code. And then you find that, and I mean, you will appreciate it as well, even with regards to the issue of the settlements and the other things, that somewhat there is an issue of the market model, that one, that it seems now the market itself, it will rearrange itself if we just go ahead with the market code. And I'm not saying that we shouldn't, but do you appreciate that there will be certain things that will require alignment between the market design as well, a framework, as well as the market code? And should there be inconsistencies, are you suggesting that we can go ahead now approve? Then should there be inconsistencies, then we can be in a position to undertake a process of amendments and all of that. Excuse me. So that is the second question. The third question that I wanted to again check with you on the issue of the market code. As you know, that NERSA has the legal mandate to develop rules. Yes, there is this the market code as well, that the Act says that we must it will be developed by the market operator, and then NERSA must approve. Just in terms of the conduct, to make sure that we are quite effective in the market and we ensure credibility and not compromise the competitiveness that we want to see in the market, or competition state of the market. So what would you say with regards to the point, the issue that was raised earlier on, that NERSA should consider having maybe market, I would call it market conduct rules, in terms of the market conduct rules, it will stipulate, for instance, the prohibited conduct, making it easy and state clearly what that prohibited conduct is, so that NERSA will then be in a position to undertake a process in line with the Act. If we, through the market conduct rules, we stipulate what is the prohibited conduct or practice, we stipulate the obligations of the market participants, reporting referrals, referral procedures for enforcement, say to a tribunal, NERSA's tribunal, and all of that, and even investigation procedures, the market surveillance, which is to detect the conduct itself. What would you say, given that suggestion that was made, that yes, you can have this market code developed by market operator, and NERSA, you still have the right to enforce that code, but it is there first, and then it will come to us, as opposed to having market conduct rules, or to have both of them? That's all from my side. Thank you very much.
Yeah, thank you, Madam Maseti. Then I'm now going to call upon our presenter, Mr. Howe, to respond. Thank you, Mr. Howe.
Thank you, Mr. Chair. Thank you, Ms. Maseti. So to talk quickly about ancillary services, I've included on our slide, it is very discrete parts of the provisions, which we certainly have some questions about. And we do believe that there would certainly be value of working with the market operator to ensure that, through a simulation, that these are fairly priced. Of course, some of the issues of liquidity in the ancillary services market, one can be through the vesting contracts framework, which provides for certain revenue to be allocated for that, which has to get consideration, but that is subject to a separate consultation paper. The second part of it, which remains a bit unclear for us at times as well, is regarding the certification for ancillary services. So in terms of the grid code, in order to provide ancillary services, a party has to be certified for this. Historically, through the Section 34 processes, it gets dealt with under those project documents. But for, say, a private bilateral project that may or may not be, well, let's assume one that is a market participant and selling to the market, that process to become certified for ancillary services isn't always clear. And I think that the electricity supply industry would benefit from that clarity. Moving on to the liquidity. The biggest issue facing liquidity in the market is, yet again, regarding the vesting contracts framework. And the reason for that is that if you have a party which is compensated elsewhere for effectively their capacity charges, making that available, that has not been available to other parties in the market who would be having to recoup their capacity costs effectively through the energy charge. And because of that, the energy charge is artificially low, given where the dominant position, given where the dominant player is, noting that they're recouping a lot of their costs through capacity charge. That would evaporate any liquidity into the market, because it would not make economic sense for a party to participate in the market, as they would not be being able to meet their LCOE. So that, yet again, is a comment that's going to come through the vesting contract framework, but it is something that as other participants in the market, we are very aware of. We've seen some of the internal Eskom data that's been provided to us by the NTCSA that is currently on a 15 variable to 85 fixed. And if that is indeed where the market lands up, I'm afraid to say that there will not be any liquidity entering into the market, because those prices artificially are just far too low. Moving on to the market design question, it's one of those where, if the department decides to later set a different direction, that is where we'd say then let's go fix that through the relevant mechanisms. At the moment, the only issue, obviously, the market code to become effective, we have to sort out other issues such as the unbundling of a wholesale tariff, such as the vesting arrangements. Those have to be in place for the market to become effective. But given where we are in the policy landscape, and given that this market has been envisaged since the white paper in 1998, I don't want to give my age away, but I was very, very young when that paper came out. The policy environment is there. It is enabling. It's been envisaged that this is what is going to be implemented. And to the extent there are any policy level changes, those would then have to be dealt with through the regular course. Looking at the conduct rules, we generally are in support of clarifying the rules where required, but we do note that as with almost all competition rules, there has to be a degree of general application, because if you become overly prescriptive, there is a risk that there might be coverage gaps. Listening to some of the other submissions that have been raised, we would fully support stability of whichever investigatory unit to obtain whatever information might be deemed relevant. Obviously, that unit has to have confidentiality mechanisms in place to ensure that, for example, they don't then publish sensitive commercial information to the public. But we do believe that they should be able to obtain any information needed to assist them with their investigation, and that it's very important that those rules are in place and that unit is properly empowered. Looking at the market conduct rules, we would have no objection if NERSA develops rules about that. We note that the market conduct rules are currently forming part of this, and we'd be happy for it to be clarified or expanded as NERSA deems appropriate, noting, of course, that it is incredibly important to ensure that market participants are acting fairly rationally and not trying to abuse their position. Thank you.
Thank you very much. So I think, therefore, at this stage, we are now going to move on to the next presenter, number 11, Madam Chanel Yar. Madam Chanel Yar, can I ask you then to switch on your video so that you can take the oath? Madam Maswanganye, I see your hand is up.
Thank you, Chair. Madam Chanel is not in the public hearing.
All right.
Yes, I tried to get hold of her, but I cannot seem to find her.
All right. Thank you for that. If that is the case, then because there were others, number 6, number 5, 6, 7, you've also given the feedback that they are now observers. So because of that, then it means that we're now going to go on to the next item, which is the closing remarks by the applicant, the National Transmission Company of South Africa. Mr. Ettinger, your closing remarks.
Thank you very much, Chair, and thank you for all the submissions which were made to the presenters of all the submissions and those written submissions which have come through. I think we've listened attentively, Chair, and I think when it comes down to the points of market design, the ancillary services, the role of the department in setting a policy framework, failure to launch, and coming back to the risk mitigation plans and the importance of doing this in a responsible way without unintended consequences. I think just are the themes which have come through for me. So, Chair, I'd really like to thank NERSA, and we will, from our side, take both the comments which have come through today as well as the written submissions and methodically work through them. The commitment that we've made to Mr. Matabula is that we would have a follow-up session with the regulator. And I think what we will do then, Chair, at that event would be then to account in terms of how we propose to incorporate the valuable input into the market code. So I think my proposal, Chair, would be that we follow that route. But once again, to thank the regulator and all the interested parties in this critical piece of work for the benefit of the country and its people. Thank you very much, Chair.
Thank you very much, Mr. Etzinger. I now see Madam Maseti, your hand is up.
Yes, Chairperson, and thank you to Mr. Etzinger. I think the information that has been requested through this platform, it's supposed to be, because it was meant to assist the members of the regulator who will not be part of the technical team that is dealing with the other information. So if that can be submitted to the Secretariat of NERSA, so that it can be made available to us. And I suspect also it will be quite detailed if you look at the issues of the due diligence as well as the risk that we stated, risk mitigation and so forth. So we would like to make sure that all of that information, we receive it so that we can decide on the way forward as the regulator. And it was also information requested in the public platform. So it's important that it comes to us, and then we will also decide how we deal with that information and what are the next steps. Thank you.
Through you, Chair. Thank you very much, Ms. Maseti, for the guidance, and we will do accordingly. Thank you.
Thank you very much. So with that situation we are in now, I would therefore like to, first of all, give assurance to all the presenters that the information that was presented to NERSA, it was in the presentations that were made and also made in terms of questions to the answers from the regulators, members. So all of that is going to be taken into consideration, as NERSA then analyzes all the information towards making a decision. So therefore, at this stage, I would therefore like to once again thank all the presenters and all the members of the public that attended, that came as attendees. Also thanks to the staff at NERSA, and as well as thanks to the members of the regulator. So on that note, the meeting is adjourned. Thank you very much.